thank you for reminding me to record. All right, so next thing. The commercial real estate broker lien. Okay, so I mentioned this just briefly when we were just kind of having our little intro there. It's a lien that's put on commercial property to be sold or leased to protect the listing broker's commission. It must be filed after the broker has fully performed, but before closing. So they've done everything that they need to do. They're up to closing. They're just waiting for the closing date. Okay, and that's when they're going to file. And then a leasing broker has up to 90 days after tenant possession to file the lien. So if the leasing broker, they've acquired the new tenant has moved in, and then they haven't been paid their commission yet, they have up to 90 days after the tenant has taken possession to file the lien. So if it's going to be a closing, it's going to be a sale, then they can file the lien just before closing, but after they've done all their work. And then if it is a lease, they have up to 90 days after tenant possession to file the lien. And again, this is just understanding that this is one of the types of liens that you can have that is a specific lien. And we talk a lot more about this in detail and how the whole process works when you get into post. So for now, just understanding what it is, because you'll see it's a little green star, is kind of understanding the general information about it is what you need to know. So it is for commercial real estate, not residential, right? And it is protecting the listing broker's commission. It has to be filed before closing if it's a sale. And then you have up to 90 days afterwards if it is a lease. It's a lease. All right, so that kind of wraps up some of the specific liens. So now we're going to talk about a few general liens. So general liens are liens that go on everything. Right? It's not just on your property like a specific lien, but it's on you as the person, right? This is like you haven't paid your income tax, and so they're going to go garnish your wages. We're talking about that kind of thing. So the first type of general lien is a judgment. Okay, and so it's always going to be issued by a court. It's a decree issued by the court. And so if they will in that decree kind of explain what is going on, maybe how you're going to have to pay it back, right? So everything's going to be included in that. So it's going to affect all of your property, both your real and personal property. So that judgment's not just on your salary, but it could actually affect your real property as well. The one that we think about most of the time is a personal property tax lien or a state and a federal tax lien. Okay, this is where you've not paid your taxes on your personal property. You've not paid your taxes for the state. You've not paid your taxes for the federal government, right? Your failure to pay taxes. So that's the one that we think about most commonly is somebody hasn't paid their taxes and they're getting a lien placed on all of their stuff. But it could be a judgment from the court, or it can also be one of these tax liens. So what is the effect of the lien on the title of the property? Well, the first thing that we learn is that it is appurtenant, which means that it runs with the land. So if it is a lien on the property, then it stays with the property, not with the owner. So just know that difference. If it's a lien that is attaching to the property, it's running with the land. It's staying with that property. It's not going with the owner. So for example, let's think about our special assessment. So with the special assessment, that's not on the person, that's on the property, right? So that is going to stay with the property, right? And so if you're selling your house and there's a special assessment, then there's actually a place in the offer to purchase and contract that says, is there any special assessment going on right now? And if so, if there's a special assessment due right now, then the seller's supposed to pay for it. If there's a proposed special assessment that's going to be out, sometime in the future, then the buyer's going to have to pay for it. But that's always something that can be negotiated with regard to the price. So that is on the property, not on the person. And so we really pay attention to that when we are looking at even the offer to purchase and contract. Priority of liens. Okay, so this is important to know. You do need to know kind of like general the priority. So the first thing that's going to be paid off if you go into foreclosure is the real property tax. You got to pay your property taxes first, and then special assessments are right up there with it. Right? So property tax first, and special assessments. But in actuality, if the house is foreclosed on and it's auctioned off the courthouse steps, what really gets paid first? Anybody know? What really gets paid first? Who's going to get paid first?
Federal taxes?
No.
The bank.
Yes. The attorney who is doing the foreclosure. So they're going to get their money. Then we're going to go to their property taxes and special assessments. Then we're going to go to mortgages in order of recordation. And then we're going to go to liens and judgments in order of recordation. And that's why we have to think about this mechanic lien being the first day labor began and materials were delivered. So that's where that mechanics lien gets a little bit of a priority, right? Because if there are a whole bunch of liens and things accumulating, they're able to get theirs in maybe above other things, because liens and judgments are paid in the order of their recordation. All right, so this is how it goes. So first thing, and that's just, they're not going to ask you on the test that the attorney gets paid first, but hopefully that'll maybe help you remember this. First thing that gets paid, property taxes, then special assessments, then mortgages in order of recordation, then liens and judgments in order of recordation, and then keep in mind that the mechanics lien is the first day labor began and materials were delivered. Now I'll tell you a little story with this. So years ago, before I was a broker, I did a lot of real estate investing, and my husband did not want me to become a broker because he said, no, you're held to a higher standard, and even though we're not going to do anything that's like, shady, I just don't want you held to a higher standard, because we'll learn about material facts going forward and how important they are. And so he would go to the courthouse and he would research foreclosures. And he found a foreclosure that a $10,000 loan was being foreclosed on. So people were losing their house over a $10,000 loan that they were not paying. This was like a home equity loan, like a second mortgage, but it was in first position, and it was the one that was being foreclosed on. There was a $100,000 mortgage that was in second position. And the only way that ever happens is if the attorney did not file the proper paperwork to make that second mortgage subordinate to the larger mortgage, right? So whenever you get a second mortgage, because it's the latest date, it's going to go first. Then the attorney files a subordination agreement so that the larger loan stays in first position. Your mortgage stays in first position. This had not been done. So what was going to happen was the courthouse steps, this house was going to be auctioned off for $10,000, and everything after that was forgiven. So everything after that was going to be forgiven. So we found this piece of property. We talked to our attorney, and he said, well, they're going to come after you. Even though it's forgiven, the bank's going to come after you. And we said, yeah, we know they're going to come after us, but do you think we could get title insurance? So he said, I don't know, we'll find out. So sure enough, we were able to get title insurance for it. We bought the house on the courthouse steps for $10,000. And about 2 months later, the bank came after us. And they took us to court. And they were like, no, you've got to pay this mortgage and all of this kind of stuff. And it went to court. And the title insurance company had an attorney that represented us. And it ended up in court. And the ultimate decision of it was that the judge told the bank, you're suing the wrong person. So this is textbook, general. They did exactly what they were supposed to do. They did everything. The person who screwed up here is the attorney. You should be suing him for not filing the subordination agreement. Right? So that's a little story maybe to help bring a little bit of reality to this and help you see why these in order of recordation is very, very important. So now, had I been a broker and I had known that, and that was a material fact, should I have probably disclosed that? Well, the jury would probably be out on that. But since I wasn't one at the time, then I didn't have to worry about that. And we were able to get a $100,000 house for $10,000. So that's the importance of the order of recordation. Okay, so now let's look about deed restrictions. Talk a little bit about a different kind of encumbrance, not a financial encumbrance, but another type of encumbrance, a deed restriction. So these are private agreements enforced by private parties. So you think about restrictive covenants. So if you are in a development that has an HOA, there may be restrictive covenants. So these are usually imposed by the developer, could be imposed by the original owner, could be imposed by the HOA, and the purpose is to maintain standards and value. So in my neighborhood right now, there are restrictive covenants. And one of the restrictive covenants is that we cannot install a chain link fence. You can't put a chain link fence in your backyard because then, or in the front yard. That would decrease the beauty of the neighborhood, decrease the value of the neighborhood. We have another restrictive covenant. If we cut down a tree that has a larger than 4-inch diameter, we must replant a tree in its place. This is a wooded, nice neighborhood, and they're wanting to maintain the value of the property. So those are restrictive covenants. Those are encumbrances. Those are things that you must follow. So I have been president of an HOA where we had a lot of restrictive covenants. And people, another one is you can't install a satellite dish so that anybody can see it from the front of the house. It has to be not visible. And so we've had people, when I was president of the HOA, that would violate our restrictive covenants. One of them was the color that you painted your house. And somebody went off and painted their house like orange. And it was not one of the approved colors. There was actually an approved color palette that had to be used in the neighborhood. And so the board first of all, they were supposed to get approval before they painted, which they did not do. So we said, you didn't get this pre-approved by the board. You must follow the restrictive covenants. You must change this paint color to a color that matches our color palette. And if you don't, we will paint it, have it repainted for you and charge you for that, plus the 10% administration fee that is included in what we say, we can do in our restrictive covenants. So that's an example of a deed restriction or a restrictive covenant, right? And again, it's there to maintain standards or value. Interesting thing about a restrictive covenant, though, is that it cannot violate existing law, right? So an example that I've seen of this is restrictive covenants used to say that you could not put solar panels on your house. Okay, solar panels on your house. But now that solar panels are a thing, right, even though the restrictive covenant says you can't do that, because there is law to trump that, then you can. So restrictive covenants can be trumped by something that is a law or something like that. I have another example that was shared with me by an attorney friend of mine. This is actually some property that is currently owned by Duke University. And the restrictive covenant said, and this is from years ago, restrictive covenant said that no one of African American descent, although I think the word that they actually used in the covenant was black, could own property in this area. That was an actual thing in a restrictive covenant on property owned by Duke University. Well, of course, now that's illegal. That can't happen, right? But it's actually still in the wording. So even though the law trumps that, my friend who's an attorney was actually working on getting the words to the restrictive covenants changed because it just looked really bad as PR for Duke University to have that in a restrictive covenant. Okay? So a couple examples of restrictive covenants will help you maybe remember those. Any questions on that? Restrictive covenants. Oh, Leslie says she still sees that today. And you're paralegal, right? Is that right, Leslie? You still see some of that going on? Yeah, I think that's right. Yeah, so that can still be around.
Can restrictive covenants be added later? Like was there a cutoff or you can't add more restrictive covenants or stuff like that?
So yes, and so when we're thinking about that, there are a couple things that can happen. Is that sometimes these restrictive covenants can actually expire. They can actually expire. So there were some that will have restrictive covenants that were good for 23 years. And then I guess they thought people would rewrite them. And then after the 23 years, they expired, and then people do whatever they wanted to. But yes, so you can have restrictive covenants that can be added. So, but typically when that's, and I'm speaking now from my HOA experience as president of the HOA. So when we wanted to add restrictive covenant we wanted to add was that people could not use their house as an Airbnb. They could not use their house as an Airbnb. So there was an entire process in our bylaws that we had to go through, and that we had to, in order to change the covenants, then we had to like have it written up, we had to present it to the homeowners, and it had to be approved by a certain majority before it could be added. So there is a process where you can make additions as things change, but it's not just willy-nilly. The board just can't go out and do whatever they want to. There's a whole process that it goes through so they can change them. And I have seen that where people, now that Airbnb is so popular, people don't want residential neighborhoods to turn into short-term rental properties, and so they are banning Airbnb. So I've seen that as a restrictive covenant. Okay, just briefly, lis pendens, legal notice, well, like we said, of pending litigation that could adversely affect the title. Okay? So the buyer knows they are taking title subject to that ruling, and it could affect their ownership of the property, could affect the title of the property. All right, so that's a lis pendens. So just be aware of that if you see that word. All right, so a writ of attachment, even though it's W-R-I-T, it's pronounced R-I-T, so writ of attachment. A writ of attachment is an encumbrance for a debt other than a mortgage. Okay? So a creditor might request that the court issue a writ of attachment against some unsecured property. And so then what happens is, once the judgment is recorded, a writ of execution will be issued, and that will direct the sheriff to sell the property to satisfy the judgment. Right? So writ of attachment, something that that you have a debt other than a mortgage, it's a writ of attachment, and then writ of execution, the sheriff can sell the property to satisfy the debt. And again, that's just a green one, just so that you'll understand that. And sometimes when you see the green little stars there, and you're thinking about, well, how are they going to use that in a test question? They're going to use that in a test question where writ of attachment is one of the answers. And in order to make sure you get it right, you have to know what it means, even though it might not be the right answer, but it can be in your list of answers. And so you need to have an understanding of what it is so that you'll know if it is the answer or is not the answer. And it won't be a distractor or confusion. Easements. So an easement is, I'm not possessing anything, but I have a right to use the land of another. A right to use a land of another. No ownership is granted. I do not own any of your property. I just have the right to use it. An example. Okay, an example. And I think this is the one that I used before. An appurtenant easement. It's going to run with the land. Right? And that would be an example of a shared driveway. So I'm able to use the driveway of another property in order to get to my house. Okay? And then the other example, an easement in gross, and that would be like I'm giving Duke Power the ability to use my property to run their electrical lines, right, for as long as Duke Power is in existence. And if Duke Power goes out of existence, then the easement would end. But as long as Duke Power is in existence, or when they are sold, whoever buys them out, right, then they can still continue to have that easement in gross. So just remember the difference between easement in gross and an easement appurtenant. So an example of this, two adjacent lots with different owners, and you're going to need to know the terms servient and dominant. Servient and dominant. So easements run over the servient tenant. You are the one providing the service, right? You are serving the other property. The tract that benefits from the easement is the dominant. That's the dominant tenement, the dominant property, right? You are dominating over the other. You're getting to use something that's theirs, right? So keep that in mind, the difference between servient and dominant. The dominant's getting to use the easement. The servient is providing the easement. And it is going to be in the title of both tracts. It's pertinent to the title of both tracts. So it should be described in both tracts. So if there is an easement that you either get to use or that you have to provide for someone else, right, it should be in the title. So when you're reading the deed, you should be able to see that. And that's one of the things when you're getting ready to list a piece of property or you're helping someone buy a piece of property, you're going to be wanting to look at the deed that exists now and kind of see what goes with it. You'll also be looking at those restrictive covenants. You'll be looking at all that information, providing that to your buyer or helping your seller gather all that so that you can put it in the listing. So easement and gross, example, power lines, that's our most common example. But you could also have an easement for propane, underground natural gas, not it wouldn't be propane, but underground natural gas, and things like that, right? So the right of use is belonging to an individual or an entity. It's not appurtenant to the land. It's usually not assignable. It terminates with the death of the easement owner. And so your most common example of this is utility easements. So they would terminate when the utility company went out of business. So that's really probably not very likely to happen. So you pretty much are always going to have those easements. And it can affect what you can do, right? You might not be able to go build a shed over the top of the natural gas line, right? If you've got an easement there, you've got to make sure that they can access what they need in order to do repairs or take care of things. So what not assignable, it's usually not assignable. So what does that mean? So that means that, like, let's say if I had this, I'm Duke Power, right? And I have the utility easement for my power lines. I can't assign that easement to somebody else. It's mine. I can't go assign it to some other company, right? It's for Duke Power to use to run the power lines. They cannot assign it to another company. Cannot assign it to somebody else. So it's not and or assigns. It's theirs. They've got the easement. If they go out of business, then it's gone. Okay, it's gone. Alrighty, so just a little picture to do this, and then we'll take a little break after this. So just kind of taking a look at easements here. And so if we look at this, the owner of lot B, so we see lot B is on the left-hand side, has an appurtenant easement across lot A to gain access to the lake. Okay, so the lake is back in the back of lot A. You see back there in the back, and you see the appurtenant easement, okay, where they can get over A's property to get to the lake. The utility company has an easement in gross across both properties. You see the easement in gross going through B and A, okay, across both parcels of land for its power lines. And then you note that lot A has an appurtenant easement across lot B for its driveway. So this one picture shows you examples of all the different types of easements, right? So it gives you, now let me ask you a question about this. So where lot B is accessing the lake across lot A, who is the dominant tenant?
Lot B.
B is the dominant. That's correct. And A then is the
Servient.
servient. Yes. And so for lot A having their driveway across B, in that case, lot A is the what?
Dominant.
Dominant in that case. And B then becomes servient. Very good. Very good. Okay, cool. All right, so so somebody asked the question, what makes this a problem topic? How do they trip you up? Well, it's not necessarily that they're tripping you up in this case. What is the problem topic in this case is some people don't understand the difference between dominant and servient. So they get it backwards. They'll say that, you know, they won't understand that the dominant is the one who's using the easement. The servient is the one who's providing the easement. So they'll get those two terms mixed up, okay? Or they won't understand the difference between those two. So that's kind of why that is a problem topic. Any other questions about easements? Yes.
Can I add, just because I do this on a daily basis,
Go
and title insurance companies will tell you one of the biggest problems that they see as far as title insurance that they get down the line is in regards to easements. It's either not known when they purchase, or it's not listed in the survey, or however that happens. And so the easements are one of the biggest things when you're listing a home or whatever.
Yes, so that's definitely something that you want to be checking out on both ends, just so you know where you stand. Because it can create issues down the road, like you're saying.
I got a quick question.
Yes.
Are you able to deny those easements? And if somebody felt like it was important for them to have, can they sue you over it? Or is that just something that you have to come together and agree upon?
Okay, so you cannot deny someone an easement that would, let's say that they needed to cross your property so that they could get to your house, their house. You cannot deny them access. Okay, you cannot deny them access to that.
Okay.
All right. So now that being said, we're not going to have just like willy-nilly easements. Okay, so there has to be like a need that is provided by the easement. So it's just not. So it's not something that's typically abused, but it is something that is a pertinent, runs with the land, and you need to know about it. Okay. All right. So let's take a break right there, and take about 10 minutes or so. We'll come back at 10:05. And we will pick up in our next topic after easements. As we're just going to talk a little bit more about those. Okay, we're going to talk a little bit more about those, and then we'll get into after easements, licenses. Okay. All right. So I'll see everybody back in 10 minutes or 11. So let me resume the recording. So when you have an easement, and kind of what we're talking about here, you know, I've got to be able to get to my house. Then you have, you know, that's an easement by necessity. So it's by implication of law. It arises because everybody has to have the right to be able to get into and get out of their land. They can't be landlocked. They can't have the only way that they can get to their house is to take a helicopter. Right, or bungee jump over something, right? So that's an easement by necessity. And so if a grantor has conveyed property that's completely surrounded by the grantor's property, thus landlocking the grantee, an easement by necessity will be created. Okay? An easement by necessity will be created. So that's what we're talking about here. You can't landlock somebody. Right? So that's an easement by necessity. Now there's another one that is an easement by prescription. And that's when the claimant has used somebody else's land for a period of time, which in our state law is 20 years. And it has to be continuous, exclusive, and without the owner's approval. And it has to be visible and open and notorious. Then you get an easement by prescription. So a property owner can prevent an easement by prescription from being created by giving permission or something like that. So I had a case where that almost happened. There was had a student in a post-licensing class who was trying to sell a piece of property for her client. And they were coming out to do the survey, and it was on a river. And come to find out, the neighbors had built a cabin on the river without the owners of the property even knowing about it. And so that's a little bit different than like an easement, but that's something that, you know, they didn't even know about it. And so it became like a controversial thing of what was going to happen. And the whole deal ended up falling through, all right, because of it. But when we're talking about an easement by prescription, that's like somebody has made use of another land for a period of time. And so, but it has to be continuous. So it couldn't be that you used it for a few months and then you stopped using it for a few months and then you used it for a few months and then you stopped using it for a few months. But don't get, you know, hooked up on it too much. Many times when there are things that are in question, you're able to go and research the records. You're able to get attorneys involved. You're able to get surveyors involved. You're able to do things like that. And we'll talk about that just a little bit more when we hit encroachment, which is getting ready to come up. So I have a question. It says, what if you have a paved easement and the servient hits his plow into the easement? Is the servient responsible to fix the driveway? Okay, so the servient, okay, it's the servient's land and you're getting over it. So if some damage is done, then yeah, the person who did the damage should fix it because that's just the right way to do things. But can things like that end up in courts? Certainly they can, because let's kind of turn this on its head just a little bit. What if I'm the servient and the dominant person, you know, trashes the driveway that we share before theirs, you know, comes off or whatever? What if they did damage to it? Then they would be the ones who would need to fix that. But again, a lot of these things end up on Judge Judy. And so, but we don't have to worry about the little minute details of it with regard for what you're going to need to know for the test, because they will not get you into that. And then in the real world, a lot of what happens is that, you know, you're doing a lot of research, or you are contacting somebody to get legal advice. And that happens a lot. Okay, so legal advice is always important with that. All right, so let's kind of pick up. So a recorded easement does not terminate automatically. The easement runs with the land. Okay, so just kind of remember that. Recorded easement does not terminate automatically. It runs with the land. But how could you terminate an easement? Well, an easement could be terminated if you didn't need it anymore. You know, maybe it was because of those trees and somebody came and cut all the trees down and now you didn't need it anymore. So that's a way to terminate it. It could be terminated because the easement holder becomes the owner of the land. So if we look back at our little picture back here, what if A bought B's land? Well, then there wouldn't be a need for an easement anymore, right? So that's another way to terminate it. Let's say that the right of the easement, let's say that it was just released. It was just released. So I released the easement to the servient tenant. Abandonment of the easement. I quit using it. Even though I had it, I quit using it. And then by non-use of a prescriptive easement. So again, you just quit using it. So even if it's prescriptive or an easement of necessity, then if you quit using them, then they no longer exist. Okay. So just a little bit about how you terminate an easement. So again, just to review, easement by necessity, you cannot landlock someone. And then easement by prescription, use of the land without the owner's approval. And there's this little acronym here called OCEAN: open, continuous, exclusive, adverse, and notorious, for 20 years. So if they haven't been to the land for 20 years and you've been using an easement for 20 years and they didn't know about it, then you get it. Okay, easement by prescription. So let's say that there was some land that was on a river and they were never there. And you started going across that land to get to where you put your boat in, and you built a dock, and then you got off, you know, into the water, and you used that water, and you did that for 25 years and they didn't know it, and you did it continuously, open, exclusively, adverse, notorious. You were doing all those kinds of things, right? Then you would get an easement by prescription. Okay? And again, that kind of thing's 9 times out of 10, 99 times out of 100, maybe 990 times out of 1,000 is going to end up in some type of attorney's office. Terminating again, just to remember that the purpose no longer exists. Maybe we, and that could be, or I bought the lot that was the servient tenement, or release of the right to the servient owner. The dominant tenement says, I'm releasing this to the servient owner. It's abandonment, or it's not used anymore. So that's how you terminate it. So then we also have things as a license. Okay, so that's a personal privilege to enter property for a specific purpose, such as permission to fish in somebody's pond. Okay, it can be terminated. It can be revoked. It is not an encumbrance. Okay, and it would terminate with the death of the party or the sale of the land. So my father used to go down to Baden Lake and fish at his friend's house, right off of their pier. He had a license to be able to do that, in case anybody ever questioned. It was his personal privilege to be able to go to that property, and he was going to fish right off of their pier. Okay. When they sold that house, he no longer had the right to go and fish off of that pier anymore because it was somebody else's now. So he would have had to go to them and ask them and get a license for them, get permission to fish off of their pier, right? So that's kind of an example of how a license could be transacted and how it might be used or how it might be terminated. Now we get to encroachments. So encroachments, this is an improvement that's going to extend past the property line. Okay? You usually can't find out about it unless you do a survey. But sometimes you can tell by personal inspection. And the big problem with this is that it can make both titles unmarketable. So it can make the title of the property that is encroaching unmarketable, and it can make the title of the property that is being encroached upon unmarketable. So it's just a hot mess when you talk about encroachment. Okay, it's just a hot mess. So I was getting ready to purchase a house a couple of months ago, and the appraiser was doing the appraisal and everything was great. And the appraiser happened to pull up the GIS photographs and noted in his appraisal, which I wanted to like shoot him for, that it appeared from the GIS photograph that half of the house next door was actually on my land. Now, if you've ever looked at GIS photographs, you know that they do not constitute a survey, and they can be off for many, many reasons. And so this was getting ready to like delay the closing, which was going to really be an issue because now the lender was requiring a survey. And so we actually went to the person who did the original surveying of the development when it was built. He was still alive, very well-known surveyor. He looked at the GIS photographs, okay, and he said, oh, they did not allow for the angle of the road, so everything is askew. Here are the original surveys. Sent that to the lender. The lender said, yeah, these surveys were done before the house was built. We're not going to accept them. You still have to have a survey done. So I had to have a survey done in less than 48 hours, which meant, one, it was almost impossible to find somebody who was going to do it. And then two, when we found the person who was going to do it, they were going to charge an arm and a leg. So that, of course, they did. And but the survey ended up showing that half of the house next door was actually not on my property. It was just like the other surveyor had said. It was just the tilt. They had not allowed with their GIS photographs for the angle of the road. So they just overlaid it over a map and the pictures were wrong, which is why you should never rely on GIS photos for your survey. The other thing that was very interesting is that had the appraiser really been concerned about it, he could have just looked. The posts they were visible. They actually had white, looks like plumbing pipe around them, marking exactly where they were, and you could easily see where everything was. So 48 hours, $1,250 later, okay, we had the survey done to prove that there was not an encroachment. And so somebody's asked the question, should you always get a new survey before buying? My recommendation is always yes. Yes, it's always advisable. Now, lenders do not require it anymore, and one of the reasons they don't require it anymore is because there's so many things that have plats done now for subdivisions, and that can, suffice for it. But my rule of thumb is, when in doubt, check it out. So if there's any doubt whatsoever, I thought there was absolutely no doubt in this, but it turns out I was wrong, right? If there's any doubt whatsoever, it's always a good idea to get a survey. Always a good idea to get a survey. So here's an example of one. And if you see right here, the neighbor's garage is encroaching, okay, onto the subject's parcel. I had this happen in my old neighborhood where I was president of the HOA. Somebody was getting ready to sell their house, and the people that were buying their house wanted to put in a privacy fence in the back. So they wanted to make sure that they could do that before they bought the house. So they had a survey done. Come to find out, 6 inches of the neighbor's garage was in the other person's property. So the next door neighbor had built a garage that encroached on the other property. And we're like, oh my gosh, what in the world are we going to do? So the neighbor across the street was an attorney who's also on the board. And what they ended up doing was they ended up creating an easement. But it could have ended up being really a mess. And so now you can see kind of why that's a problem. It could make both titles unmarketable, or it could cause a lawsuit, or somebody could try to force you to take down the garage or move the garage in that particular situation. So survey is always a good idea. If you have to spend normal survey prices, not what I had to pay, but normal survey prices, $400, $500, $600, something like that. Of course, it depends upon the size of the property and other things that are involved, right? So you always get a quote for that, but it can end up saving you a lot of hassles down the road. So encroachment is something that you always want to guard against. Okay. Taxes, property taxation, North Carolina. All right, general ad valorem tax, The Machinery Act, not to be, it starts with an M, but it's not mechanics, it's machinery. The Machinery Act governs taxation. And your general ad valorem value is the market value of the house. And then who's going to levy these taxes? It could be the city, it could be the county, it could be the town. If you live in the city, you're going to have to pay city and county, right? And then it's going to be for all real property subject to tax unless exempted. The house that I just purchased in the mountains, the previous owner was a disabled veteran, and he had a discount on his tax because of that. So when we were looking at this house, I had to go and research the fact that the tax I was going to pay was going to be more because he had a discount. And I really hadn't encountered that very much in the past, but that was an interesting thing. So when you see unless exempt, why, how might somebody be exempt? Well, they may be totally exempt, or they may be partially exempt, and it could deal with their status. And that was why his was, because I had to go research that. There's a mandatory octennial reappraisal. So that's every 8 years. They must go out and reappraise properties. Okay? So the city's going to go out. You're going to get a letter in the mail. It's going to tell you that your property has been reevaluated. Okay, and here's the new value. Now, every 4 years, they could do what's called a horizontal adjustment, a horizontal reappraisal in the 4th year. So mandatory every 8 years, horizontal adjustment in the 4th year. All right, so this is not a hard topic, but it is a tricky concept. Okay, so what you need to remember is the octennial reappraisal. Remember every 8 years. That's a potential text question. Remember that it's a horizontal adjustment in the 4th year. Horizontal reappraisement or horizontal adjustment in the 4th year. Remember that. How often can the ad valorem tax rate change, though? The tax rate can change every year. Every year. Okay? So that's where they trip you up. They'll say ad valorem tax rate, and people go, oh, it's every 8 years. Every 8 years. No. The rate. So look for that word rate. Okay? So here's how it works. This is a really cool kind of thing. I like kind of explaining this. So on January 1 of this year, 2020, a lien was attached to your property, okay, for your ad valorem taxes. By January 31st, all real and personal property must be listed. Okay, so sometimes you'll get something in the mail and it'll say, have you done any improvements? You know, in the past year, we have to have this form back by January 31st. Is there something new that you've done? Right? And so that's your January 1st deadline. Then the fiscal year, okay, you typically get your new tax rate established by July 1. And then the tax bills come out September the 1st, and that's when they are due and payable. You have to pay them by December the 31st if you want to count them on that year's income tax report. And then January the 6th of the following year, 2021, is when you become delinquent in your taxes. Okay? So looking at that timetable, that's an important timetable. That September 1st date is an important date because when we get to looking at problems about prorating taxes, one of the things that you'll have to know is if the closing was in April, have the taxes been paid yet? Well, probably not unless they tell you they were paid because the bill hadn't even come out yet. If the closing is in December, have the taxes been paid yet? Probably, right? Because the bill was out on September 1st, unless they tell you that they haven't yet been paid. Okay? So that September 1st date is important. It's an important date because that's when the tax bills come out. But remember, January 1, the lien is attaching to the property. So all of you guys, we all have a lien on our property right now for our taxes. Okay? The rate will be established July 1. The bill will come out September the 1st. If you pay it in September, I think you get some type of a discount, right? It's a little bit less. But if you wait until, like I do, and then you pay it on December the 31st or December the 30th, or you're trying to get, the maximum benefit of that, then you pay it by then so you can include it on next year's income tax. If you don't pay it by the 6th of the following year, then you become delinquent. So here's just a little, if you like, a visual of this timetable. January 1st, the lien is filed. January 5th, last year's taxes must be paid because if not, it becomes delinquent on the 6th. And then you can kind of see the rest of the timetable there. So if you like a visual of it, you can kind of see the timetable right there on that visual. Special assessments. So special assessments, the taxing body, right, the city, the county, they can levy these assessments to the public for improvements that are made to the property. And it's going to be superior to all other liens except for your ad valorem tax. So ad valorem tax is number one. Okay? Then you have your special assessments right after that. So remember that in the sequence of events. Okay? So it could be that, what are these special assessments for? We kind of talked about that. It could be for putting in sidewalk, curb and guttering, putting in natural gas. Those types of things can be things that you would get a special assessment for. And it's for benefit of the entire public, right? So it's not just to benefit just a few, but it's something that's coming to benefit everyone. And so they're having to assess to benefit everyone. Special assessments are something that you need to make sure people are aware of when they are purchasing a property. If it's coming down the road, if it's a proposed assessment, the buyer's probably going to have to pay for it unless it's negotiated differently in the contract. If it is one that has already been assessed, we know that it is right now, then the seller's going to pay for it. All right, so let's do a little bit of math. So this is our first little math go at it here. So your annual taxes. Think about this. And one of the ways that I think helps with math is to put yourself in the position of having to do the calculation for your property. So your annual taxes are the assessed value of the home, also known as the tax value. What's the tax value of the house? okay, what's the market value of the house? What are we going to sell it for? And sometimes we'll say, oh, well, the tax value is really only 75% of what the market value is going to be. But one time every 8 years, they should be identical. And that's on that day of that octennial reappraisal, right? That's the day when the tax value and the assessed value are going to be exactly the same. So one of the things that you kind of like to say is, oh, I want a low tax value, but a high market value. They don't have to pay very many taxes, but my house is worth a lot of money, okay? And that might occur towards the end of that reappraisal time. Might occur towards the end of that appraisal time. But it's supposed to be relatively close. That's kind of the idea. So annual taxes are equal to the assessed value times the tax rate. That's what you kind of need to remember. And then there are other ways to adjust that formula. Assessed value is annual taxes divided by the tax rate. Tax rate is annual taxes divided by assessed value. But most of the time, we're going to be figuring annual taxes. So we're going to take the assessed value and multiply it times the tax rate. So for example, they'll say the tax rate is $1.67 per $100 of value. If the value of your home, okay, is $120,000, that means you've got to pay $1.67, right, for every $100 of value. So you're going to take $120,000, divide it by 100, and then multiply that times 1.67. And that will give you 2004. The other thing that now here's what they like to trip you up on with regard to the test. The city tax rate is if it's located in the city. The county tax rate, you always pay. So what they'll put on the question is they'll give you both the city and the county tax rate, but they'll tell you the property is located in the county. And of course, one of the answers will be the correct answer with just the county rate. The other answer will be the answer with the city and the county rate. And so some people will miss that because they see two numbers and they think, oh gosh, math, two numbers, let me just multiply them all, instead of reading the question very carefully. Okay, that's a little bit of an introduction to that. All right, so monthly tax liability. This is what you think about when we think about escrow. Think about escrow. Right? So our assessed value, let's just say it's $133,000, right? That's what our tax value of our home is. The tax rate is 1.678 per 100. So you can take 133,000, divide it by 100, and multiply times 1.678, and you'll get 2231.74. Some people like to do their math a little bit differently. They'll take the 1.68 and divide it by 100, right, which is going to get you that 0.01678. They'll multiply that times 133,000, and they'll get the same answer, 2231.74. Now, but then if it says, what's the monthly, so this is another time where they might want to trip you up. What is your monthly tax liability? Like if you're having to escrow, then you would have to divide that by 12, and it'd be 185.98 per month that you would pay for your taxes. Okay? So that's a little bit of how the tax stuff works on that. Okay? So general questions about that, because I want us to try a couple of these and see how they come out. So that's what we're going to do next, is try a couple of these and see how they come out. So any questions before we dive into actually doing a little bit of math? And then I'll show you, and then as we do a little bit of math, I'll tell you some of the things that might, go wrong.
Yeah, yes. Can you clarify? So when you said the county and the city, so there will be times where you'd have to, if it stated the property was in the city and the county, where you'd have to add those numbers, right?
That's correct. That's correct. So maybe you'll have a question that says, what's the assessed value of a house located in the county if the city tax rate is 80 cents per 100 and the county tax rate is 50 cents per 100?
Got it. Okay.
So then you'd have to know, oh, it's county only. Or they may say, what's the assessed value if the county rate is this and it's in the city? So that's kind of the way they'll trip you up on that.
Okay.
Okay. So let's look at, in your book, I want you to go to page 68. and I want you to right now look at number 18. Look at number 18. So I'm going to shift gears here and pull up my textbook online here. And so you round appropriately. You round appropriately. So if it's, so just like it's real money. So this is just like it's real money. So we're going to look at number 18. So this is number 18. Okay, so everybody look at number 18. I'll give you a minute or so to do that on your own, and then we will take a look at it together. All right, so this is a pretty easy one, right? This one shouldn't be very difficult. And now we're going to get super fancy. And when we get super fancy, I have to rely on you guys to tell me numbers. Okay, so just so you know, because when we get super fancy, I'm bringing up my whiteboard here so we can do the math together. All right, so this one says that a property is appraised at $129,000. So we've got $129,000, okay? And then it says that if the assessed value is 75% of the appraised value, what's the assessed value? So we're going to multiply this times 75%. Okay? So if you have your calculator and it has a percent key, you can type in 129,000 times 75%, and that will give you the answer. So what did we get our answer to be for this one? Anybody want to venture a guess?
96,750.
96,750.
96,750, very good. So we're getting 96,750. Okay, so that's exactly right, 96,750. Okay, cool. So that's an easy way to do the math. It's kind of, you know, starting it off. We're starting it off here, and we're just kind of going to build up. We're going to build up just a little bit. So we got 96,750. Okay, great. All right, so now a little bit more of our example here. So I want to go back and look at our formula again. So we said that if you take the assessed value, okay, times the tax rate, okay, and then that's going to be equal to the amount of tax that you have to pay. Okay, and I like looking at formulas like that. Value times rate equals the amount of tax. I kind of like looking at it like that because I come from a science background. But there's another way to look at this using something called the T-bar. So I want to show you the T-bar. So when we have examples in class and we're doing problems in class, I will probably show you how to do it both ways, with the formula or also using the T-bar. Okay, so let me just clear this drawing and let me get rid of this. So if I'm going to have value, I'm just going to make this a little bit smaller. Value times rate is equal to tax. Okay, that's the amount of tax I'm going to have to pay. So another way to look at this is with the T-bar, is that the amount of tax I'm going to pay is going to go up on the top. And then I draw a T. Okay, and my rate is over here. And then my total value is over here. Okay. So this is just another way of kind of reorganizing this particular formula up here based on the equals. So when we have back from Algebra 1, when you learned Algebra 1, you knew that I have things multiplied here. If I take something to the other side of the equal marks, now I'm going to have to divide by. So if I took rate to the other side, I would then divide by it, and that would leave me with value. Okay. So if I then, instead of taking rate to the other side, I took value to the other side, I would divide by that, and it would leave me with rate. Okay. So that's the way that that things kind of, you know, work out when you're doing it using algebra. But some people kind of, they're like, oh, algebra, don't talk to me about algebra. So we can also look at it at the T-bar, and the T-bar kind of sets this all up in the algebra for us already. So the line right here, if something is on, this is our dividing line. Yeah, and we have to be able to spell divide correctly for this to make sense. So this is divide. Okay, and then right here, this is multiply. So it's kind of doing the exact same thing, only we're kind of setting it up in another way. Here's an easy way to remember this, okay? Because you're going to have, when you're doing this, you're always going to have a rate, okay? And your rate is usually going to be some type of a percent. You're always going to have that. Then you're going to have a large number, and you're going to have a small number. The large number will always go right here. That's always going to be the largest number. And this will always be the smaller number. Okay, so when you're setting something up with the T-bar, you remember that. The smaller number is always going to go on top. The rate's always going to go on the left. The value is always going to be the largest number, and it's going to go here. Okay. So questions about that while we're looking at the T-bar?
Is the larger number going to be the assessed value or the appraisal value?
Okay, so sometimes they're going to give you a step, like they're going to say that the appraised value is 200,000. Okay, and the assessed value is 80% of that. So you're going to have to go 200,000 times 80% to get the number that's actually going to go into your assessed value. Okay, so sometimes they'll give you 2 steps to the process. So you'll have to do something to get to this number, and then you'll multiply it times the rate to get your tax. Did that make sense?
Yes, ma'am.
That was a yes? Okay. All righty. So let's look at another one here. We're going to look at number 20. We're going to look at number 20. So I'm going to give you guys a chance to, oh, wait a minute. Let's look at 19. Let's look at 19. Okay, so go ahead and do 19 on your own. And while you're doing that, I'm going to kind of set it up here. So do it on your own. Give you just a minute or so to do that, a minute or two, and then we will look at it. So when you're finished, if you want to put the answer you got in the chat box to me privately, you can do that. That way you don't have to be embarrassed if you get the wrong thing, because I won't remember. I'm starting to see several people put an answer in. So let's go ahead and kind of start to work through this. So the house was appraised at $389,000 for tax purposes. It was assessed at 85% of the appraised value. Okay, so I want somebody to help me walk through this problem. So what's the first thing that you're going to do? Who can tell me what's the first thing to do?
Find the
Times 85%.
percentage of
So the first thing I'm going to do is I'm going to multiply 389,000 times what?
85%.
85%.
That's right, times 85%. Okay, because that's the assessed value. That's what I'm being assessed on. And so what is that number?
330,650.
330,650. Okay, great. So then it says that the taxes are $1.10 per every 100. How much were the taxes? Looking at two different ways to do this. If I'm doing this in my mind, just like the way that I'm going to do it, I'm going to say 330,650. Okay, and then it's $1.10. So I can say $1.10 for every $100, and that's the way that it is, right? And so I can then multiply 330 times 110 divided by 100. I can take 330 divided by 100, multiply times $1.10. And when I do that, regardless of how I do it, I get the answer of 3637.15. Because everybody was telling me C, I'm assuming they were correct, 3637.15. Now, if I did this on the T-bar, this is how it would look on the T-bar. I'm looking for the amount of tax that I'm going to pay, right? So I'm drawing out my T-bar. I've got my 330,650 here, okay? And I've got my $1.10 divided by 100 over here, okay? So that's how it would look on the T-bar. And then I would take the $1.10 divided by 100, multiply times the 330,650 and get the tax. So that's how that would work. Make sense? Any questions? Okay, when we see the word ad valorem, okay, that's the way ours are done. Ours are ad valorem. We know that this is going to be per every 100. So it's per $100 of value. Okay. Every now and then, though, and sometimes on a test, you will see the term per mil. Okay, and if it's per mil, then it is actually, that means instead of 100, that means per $1,000. So when you see mil, it's 1,000. So in our previous example, if they had said the taxes were $1.10 per mil, the only thing that would have changed is, and I'll just do the T-bar here, the only thing that would have changed is the $1.10, instead of being divided by 100 for ad valorem, would have been divided by 1,000 because it said mil. Okay? Does that make sense to everybody? So if you see mil, it just means divide by 1,000. And otherwise, when you see ad valorem, we're dividing by 100. Cool? Cool with that?
Yes, thank you.
Awesome. So now let's do number 20. So we'll give everybody a chance to do number 20. And see what we get for that. Okay, so it looks like some people are finishing. Give a few more seconds here for people to keep working. Now, if you're freaking out about the math, don't freak out about the math. We spend a lot of time on the math as we go through. And if you need extra help on the math, you now see that I have a whiteboard that I can help you with math. So if you need any math tutoring online, we can do it online, and I can share my whiteboard with you, and we can work it out. So this is the greatest tool that I ever had. This is my iPad is actually connected into the meeting. There's no sound coming through it, and then I'm writing on it with my Apple Pencil, so I can use it just as a whiteboard, so that everybody can see that. So that's a pretty cool invention there. All right, so number 20. So somebody needs to walk me through how to do number 20. What do we need to do for number 20? Did everyone just like fall asleep or what? Who can help me with number 20?
Multiply the market value times 80%.
Okay, so we have market value is $295, and then we say that the assessed value is 80%. So we're going to take 80% here, and then what do we get our number to be?
136,000.
Did I hear 236?
Mm-hmm.
236,000. Okay, and then now this is telling us that it is outside the city limits of Greensboro.
You're just going to do county, right?
That's correct. So the city tax rate is 0.84 per 100, county tax rate is 0.63. So it said that it was outside. So now I'm going to take my 236. I'm going to multiply it times, what was the county? 0.63.
0.63.
0.63 per $100. And when I do that, my answer comes out to be what?
0.0063. Oh,
yeah, 0.0063, or is that? What?
Ends up being 1486.8.
1486.8. Okay.
And then divide that by 12.
Yeah, they said, what's the monthly? So we've got to divide that by 12. And then that gives us, what is that?
2390.
2390. Okay. Now, this was one of the ones where they were trying to trick you up. They gave you the city and the county, but you only needed the county. You only needed the county. So if I put this in the T-bar, sorry, I'm going to have to like clear this to get the T-bar on here. We were at, what was this? We're looking for the tax. Okay. And this was 236, I believe, if I remember correctly. 236. And then we had 0.63 per 100. Okay, that's how we'd set it up there. We'd still get the same tax, which was 1486.80. And then you've got to remember to divide that by 12 to get the answer.
I'm loving it.
Any questions? Is that making sense?
Yes.
Good. Yes. Good. We always like it when the math makes sense. All right, let's do one that takes us a little bit backwards. Let's look at number 15. Let's look at number 15. So we went forwards first. Now we're going to go backwards. We're just going to be filling in a different part of the T-bar. So try that one, and then we'll see what we get for that. So I'm starting to get some answers on this one. But I'm getting different answers. This is one that, even though I'm not I don't use the T-bar all the time. This is one where I find that using the T-bar is a quick way to do it. It's a quick way to do it. So I'm starting to get plenty of answers. So let's set this up. So if I'm going to use the T-bar on this one, just to kind of show you what that would be, it tells me that the annual taxes are $1,600. I'm going to put 1,600 up here, right? And what I'm looking for is the value. So I'm looking for this. That's what I'm looking for. It tells me that it's located in the city. Okay? It's located in the city. What's my rate going to be?
1.30.
Yes, it's 1.30 for every 100. Okay. So I would take 1.3, divide it by 100, right? And then to take 1,600 and divide that number into it. So if we take 1.3 divided by 100, what do we get?
0.013.
0.013. So 1,600 divided by 0.013 gives me 123,077. Actually, 123,076.923, but we will round up to the one that's closest to their answer, which is 123,077. Okay, so if you did not get 123,077, any questions? What did you find out what you did, where your error was? So this one was actually inside the city, so we had to do both city and county. So if you had done like 0.8 or 0.5, you would have gotten one of the other answers. So they were trying to trip you up on that.
I'm sorry, where did we get the 1.30 from?
Okay, so where did we get the 1.30? So the 1.30, so this is what we're saying here. We're saying that we're looking for the value. Somebody said do it without the T-bar, so I'll do it here. So the value times the rate, we know that's per 100, right, is equal to the amount of tax that I'm going to have to pay, which is what, 1,600, right? Okay, 1,600. So it says that the city tax rate is 0.8 per 100, 0.8, and the county tax rate is 0.5. And since we live in the city, we have to pay both of those. And so 0.8 and 0.5 is going to be 1.3. Okay.
Got it. That's where I got tripped up. I forgot we have to do both. Okay.
Do both, right. So if I'm doing this without the T-bar, I'm going to set it up like this. Is what it's going to look like. All right. So then my next step is going to be 1,600, and I'm going to take 1.3 divided by 100. Right. So that's going to be your next step. And so 1.3 divided by 100, you guys told me was 0.013. 0.013 times value. Okay, so this is without the T-bar. So now I know I got to get value all by itself on this side of the equal mark. So that means I got to move this one to the other side. And when I move it to the other side, I have to take it to whatever it was not. So here it was multiplied. So if I take it to the other side, I got to take it on the other side of that dividing line. So 0.013 goes down here. 1,600 divided by 0.013, and that gives me my 123,077. Okay, that's how you do it without the T-bar.
Can you do it? I didn't add the 80 and 50 together. I was doing them separately. Can you do them separately and then add at the end? You
can if you want to. It might be a little bit longer step to do it that way, but you most certainly can. You're going to get the exact same answer. So you can do them individually and add them up, or you can add the rates up and do it that way. Either way that works best for you and helps you think about it logically is the best way to do it. Okay. So other questions, anybody? Okay, well, after that much math, I think that we have earned ourselves a break. So let's go ahead and take a break. It's about 11:01. We'll come back around, 11:15. Let's take a little bit longer break. We'll come back around 11:15, and we will continue on from there. That'll take us up to lunchtime after that. We'll take a good long break, about 15 minutes, and we'll come back. And when we come back, we'll be starting Unit 4. The recording, and I thought we would do a couple of little questions here before we get into the next chapter. So, logical reasoning. A property owner sells her property to a group of 3 concurrent owners with the condition that it must always remain a horse farm. Each of the owners contributed an equal amount of their interests and will pass to the other owners upon death. The new owners own the property most likely as how? You can put in the chat box your answer. Okay, so I'm getting some little mixed things here. So let's figure out this, take this question apart here if we can. And let me see if I've got slides to do that. All right, so the first step is to determine what the question is. Property owner sells her property to a group of 3 concurrent owners. That's a key point, 3 concurrent owners, with the condition that it must always remain a horse farm. Key point. So we've got 2 things going on here. 3 concurrent owners. 3 concurrent owners leads us to think it's what? What?
Joint tenant.
Joint tenants, that's correct. Condition that it must always remain a horse farm tells us what?
Determinable.
Determinable, right. Each of the owners contributed an equal amount and their interest will pass to the other owners upon death. So that confirms, right, if it's passing to the other owners, that confirms joint tenancy. So our first one made us think 3 concurrent owners. We started thinking joint, but that could have also been tenants in common. But with the interest passing to the other owners upon death, that makes it joint tenancy with right of survival. So that confirms it for us. The new owners will most likely own the property as, okay, so let's look at each of our answers here. Fee simple absolute cannot contain conditions.
It's the
Qualified fee is joint tenants, correct? Because the condition is imposed, that's qualified fee. Equal ownership with right of survivorship, that's the other thing that they told us. Qualified life estate, no life tenancy. Leasehold, no lease, and then the owners own. So that's how the others were not correct. So that kind of takes you through that logical reasoning step there. Okay? So remember homework and quiz, and a little bit here, we're going to do some of that as we get to the end of this. So this particular time frame right before lunch. All right. So I'm going to save that and get on to our next PowerPoint. I have to change PowerPoints. I have to update my slideshow right way so that my microphone continues to work. It's really weird, but whatever. We just go with it. All right. So again, reminder here, I think everybody's probably getting pretty close to understanding our highlighters here. Remember our levels and our problem topics in North Carolina specific. We don't see that after today. I just have it in the first few unit slides, just as a reminder. So property description. All right, for this, we're going to talk about types of legal descriptions. And this is important really it's important for the test, but it's also important for your knowledge in the field. We're going to describe the importance of survey. We've kind of already talked about that a little bit. Discuss the legally acceptable method of property descriptions. And we'll calculate some land measurements. So we've got some more math to rock and roll with. Okay. So describing land. The legal description is the exact location of a parcel according to an established system. And so it's sufficient if a licensed surveyor can locate the parcel with that description. So that's just our basic way that we describe land. There has to be a legal description to the exact location. And we know that it's valid, all right, if a licensed surveyor can actually locate the parcel based on that description. So there are 4 methods to describe land. The first is called meets and bounds. Okay. This is the most common that you're going to see in the state of North Carolina, meets and bounds. This goes back to ancient times. And so when we look at some of these, and like back in when the country was first ancient, not really that ancient if you're thinking back to the caveman, no. But we're thinking about back to the time when the country was first founded. And so if you see something that says starting at the big tree, and you're thinking that can't be a legal description, well, actually it can, because that's meets and bounds. So you are describing it based on various landmarks and directions. Reference to a recorded plat, that's what you're starting to see now in subdivisions. It's also called lot and block. So you'll know which block and which lot it is. Reference to a publicly recorded document that contains the legal description. So sometimes I think attorneys get lazy and if the legal description, and you can verify this, my paralegal, is like a page and a half long. I have seen I've seen a reference saying the legal description as found on page so-and-so of the book such and such, and that's where that page and a half legal description is. Okay? And so that is valid. Reference to a publicly recorded document that contains the legal description is a valid way to do it. And I'm just joking about attorneys being lazy, because you can joke about teachers being lazy too. They never work in the summer, right? So we all have our little things we can just laugh about. And then we have the government rectangular survey system. And this is typically done west of the Mississippi River. Not a lot going to be tested on that on the test, but you still need to know certain key things about it. So those are your 4 methods of describing land. Meets and bounds. So this was the primary, as I said, ancient times. This is the primary way the original 13 colonies did it. It must start at a point of beginning, and it must end at that point of beginning. Okay, so that is your designated starting and ending point. So if it were a circle, it'd be like you're going to complete the circle, or the square, or the rectangle, or whatever. You have to end where you start. Okay, so that's how it works. Your monuments can be fixed objects, stones, lakes, highways. That's how you're describing things. Meets are the distance, and bounds are the direction. So meets are the distance, bounds are the direction. Okay? So an example might be beginning at a point on the southerly side of Kent Street, 100 feet easterly from the corner formed by the intersection of the southerly side of Kent Street and the easterly side of Broadway. Thence, right? Then you go on to the next part. Okay. Another one might be beginning at the intersection of the east line of Jones Road and the south line of Skull Drive, thence north 90 degrees east along the south line of Skull Drive 200 feet, thence south 15 degrees east 216.5 feet more or less to the center thread of Red Skull Creek, thence north 4 degrees west along the center line of said creek to its intersection with the east line of Jones Road, thence north 105 feet more or less along the east line of Jones Road to the place of beginning. Now, when you listen to that, can you believe that's a legal description? Isn't that incredible? Isn't that incredible? But that's exactly how it's done. That's exactly how it could be done. Now, what you're going to see now is typically now you've got rebar hammered into the ground. to mark the different points, and that makes it a little bit easier to find. But the legal description is still that meets and bounds legal description. And Leslie is telling us that those can cause problems. Anything specific you want to say about that, Leslie? Don't forget to unmute. Leslie, are you there? Okay, maybe nothing.
I'm sorry.
specific.
What?
I was just going to say, anything specific about, did you say that those meets and bounds can cause problems?
So not necessarily the meets and bounds. Can you hear me okay?
Yes, just fine.
No, not necessarily the meets and bounds. I was referring to anytime you reference an already recorded document, those are extremely problematic.
Okay, perfect, perfect. So yes, referencing a previously recorded document. I've seen it done, but I think it can be problematic. You're right. You're right. All right, cool. Okay, so here's an example of meets and bounds. And there's a monument, your point of beginning, and you can see how they're saying 80 degrees east, 180 feet. Then you're turning in the different directions. All right, so that's kind of an example of meets and bounds. So rectangular government survey. This is really cool. Okay, we can't use it here because we are not flat. But out west, where things are flat, you will see the rectangular survey, or also known as the government survey system. And it's based on a grid system. And you do need to know that the principal meridians run north and south, and the baselines run east and west. Okay, so just know meridians are north and south, baselines are east and west. The most likely thing they're going to ask you, though, is this, what's in red in the middle. The basic units are townships. Townships are 6 miles square. They contain 36 sections that are 1 mile square each, and 1 mile square is 640 acres. Okay? They're mainly used west of the Mississippi River. They're based on a grid system, and here's our grid system. So if you see the subdivision of a town system, right there in the middle, you'll see sections. Notice that they are labeled starting on the right and going to the left. So 1, 2, 3, 4, 5, 6, then you drop down to 7, 8, 9, 10, 11, 12, then you drop down to 13, 14, 15. So you see how that's the way the 36 are numbered. Okay, so that's the way it looks like, and that's a township. And these are laid next to each other. So there's going to be another one to the right, another one to the top, one to the north, one to the south, one to the east, and one to the west. And that's how they're done, okay, and those sections of 36, and then 36, and 36, and 36, and 36, and 36. So if they asked you in a question, what is the section number that is due west of section 7, what would the answer be?
That'd be 12.
Yes, it would be 12. And how did you get that?
I just imagine there being another plot of land, and with it being going from right to left, it would be 12.
That's exactly right. Yep. So we would just lay another one of these right next to it. And so next to the 7 would be the 12. Next to the 6 will be the 1. The 7 will be the 12. The 18 will be the 13. And if we were on the other side, then next to the 1, okay, would be the 6. Next to the 12 would be the 7. And so they're all laid out like that next to each other.
Can you re-explain that? I'm sorry. I'm a little
lost. Yeah. So think about, this looks like a bingo card, doesn't it? Looks kind of like a bingo card with a lot of blocks. So you've got your first bingo card right there with your subdivision of township. Think about laying another bingo card directly next to it on the right-hand side. I laid another bingo card directly next to it on the right-hand side. What bingo number would be next to number 1? Number 6, because I had 2 cards laid next to each other, right? And so the left-hand side of the card on my right is going to butt up against the right-hand side of the card on my left. And so think about two cards laying next to each other. Did that help?
Yes, that did. Thank you.
Perfect, perfect, good, good. If I needed to, I can get out my whiteboard and draw it, but I think that probably will take care of it. So the legal description, if we look at the one on the right-hand side there, the legal description, we're looking for the little block that we see shaded in there. That is going to be the northeast 1/4 of the northwest 1/4. Okay. South 24, T23, NR4E. Okay, so so that is the, if you look at that, that is the northeast 1/4 of the northwest 1/4. There are none of these on the test. You do not have to figure out the rectangular survey system and figure out where something is, okay, on one of those blocks. It's just kind of a fun thing to do if you enjoy kind of looking at some math, playing around with a few calculations. You will not have to worry about that. Okay, you're not going to have to do math on that, but it is kind of fun. What you do need to know is that the section in the middle, see section 16, that is always the school section. The school is always located in section 16 because that's like the middle of the township. So you're going to have your school in section 16. So you need to know that there's 6 square miles, right? Each townships are 6 square miles, which means they contain 36, because 6 times 6 is 36, 36 1-mile squares. Okay, so just remember that. So remember these things. And 1 mile square is 640 acres. 1 mile square is 640 acres. Okay. So those are the key things to know about that. So if you're going to record one of these descriptions, right, you may record it as the southwest 1/2 of the northwest 1/4 of the southeast 1/4 of section 11. So if we're kind of looking at this one here on the right, this subdivision of section, the legal description of the shaded area is the northeast 1/4 of the northwest 1/4 of section 24. You don't need to worry about the T, the N, and all that. Okay, you don't need to know about the third one north and the fourth one east, but you stop at the section, right? And so we're looking at section 24, and then it's the northeast 1/4 of the northwest 1/4. So we think about dividing it into quarters and then quarters again. So the northeast 1/4 of the northwest 1/4. All right. So I feel the need to put this on a whiteboard. So let me do that. Let me escape out of sharing my screen here, and let's go to the whiteboard. So what we were saying there is we were seeing that we were in section 24. So we already know we're in section 24. So this is section 24. And then it said the southeast, did it say the southeast 1/4 of the northwest 1/4? Is that what my question was?
Northeast.
The northeast 1/4 of
the northwest.
Okay. Northeast of the northwest. Yeah, that makes sense now. Okay. So the northeast 1/4 of the northwest 1/4. Okay. So I divide it into quarters, right? And so I know that this is north, south, east, and west. So what's the northwest 1/4 is this box right here. And then I'm going to take the northeast 1/4 of that box. So again, north, south, east, and west, the northeast 1/4 becomes where I've shaded it in. So that's how you figure it out.
That helped a lot.
Make sense?
Yes, it does.
You don't have to do one of these normally on the test, but it's kind of a neat thing to understand. I think they're kind of fun to go with it. So if I am doing the northeast 1/4 of the northwest 1/4, I want to know how much this is. What I do is I take these numbers right here and I multiply them. So 4 times 4 is 16, right? So that's 16. And then I know that each one of my boxes is 640 square miles. I mean, 640 acres, not square miles. 640 acres. Must be getting time for me to eat here pretty soon. So I take 640, I divide it by 16, and that's going to tell me how large this section is. Okay, so 4 times 4 is 16. That's how I get that. And then 640 divided by 16 tells me how large that section is. Now, if you're a little fuzzy on this, don't sweat it. This is not on the test. It's just like kind of helping you understand how it works. So 640 divided by 16, who's got a calculator? Super handy.
40.
40, there we go. So that's 40 acres. 40 acres is that amount right there is 40 acres. So that's how you figure it out. So it's kind of fun. I thought this, I can remember when I was in class, I thought these were super cool because they were like little puzzles and you had to figure it out and you had to draw things out and color it in. And I thought that was super cool. And then I found out there was going to be none of them on the test. And so, oh well. But it was still kind of it was still kind of cool to figure out how it worked and just kind of see how that works. So hopefully that made that a little bit more clear, a little less muddy, a little bit more clear. Understandable. All right, so let's see if I can get back into my show here now. Slideshows. All right. So next one, lot and block. So this is what we see a lot now in subdivisions. Recorded plat or a subdivision plat. It's recorded in the county where the land's located, and it is the most common and worry-free method for urban property, right? So if you are in one of these subdivisions that has this recorded, you already know where everything is. You typically do not need to go get an extra survey, right? So reference to a recorded plat, because that plat has been approved and it has been surveyed and everything should work just fine with it. So here's the way we see this. So this is lot 4, block B of the rolling acre subdivision. So we can see block A, block C, and then block B and lot 4. So that's how you would identify that particular one. And so on your MLS listings, when you're doing descriptions, you're going to have to put in all the ones that you know. So you might put in the lot, the block. You're going to put in the reference to a recorded plat. You're going to do that. Fortunately, you do not have to type in the entire meets and bounds legal description. That's what the attorneys do on the deed, but you'll put in all of the other information. Reference to recorded deed, here's one of those. Deed book 2132, page 541 of the Carteret County Registry. So it is a previously recorded deed to the identical parcel that contains a legal description. Okay, it's seldom used today because things are now, we have electronic means of doing things. So even if you have to take a PDF of something, you can convert that to a Word document, tweak the words, and you're not having to retype 2.5 pages of stuff. But long back before we had technology, right, which could have been back in the 60s, you would see this more commonly done because it was such a pain to retype everything. So you would see that much more commonly used back in that day. An informal reference, that's your address. That's your street address. That's informal. So 123 Maple Street is an informal address. Okay. It is often used in a listing contract, or it's used in a lease, like 123 Maple Apartment B. Okay, we've got that. We know that. But it cannot be used, okay, as the only reference in a sales contract. You cannot put that as the only reference in the sales contract. Okay? Should not ever be used as the only reference. So you should have 123 Maple Street, then also the lot and block, okay, or something like that included along with it, so that it is not the only reference that you have. Surveys. Survey would be prepared by a licensed surveyor, and it is the best method to discover an encroachment, any title insurance issues, or even if the property is located in a flood zone. It's located in a flood zone. Because there are lots of issues we'll find out in our chapter on insurance with regard to flood zones and what is required if you have a loan. You're going to have flood insurance. Other times you have to have flood insurance. Should you always have flood insurance if you're in a flood hazard zone? Well, yes, but do people? No, but we're going to learn all about the specifics on that when we get to our chapter, unit 13 on insurance. But that is a problem topic, okay? Survey is the best method to discover encroachments, title insurance issues, and in flood hazard zones. Okay. All right, so that's unit 4. Unit 4 is a short one, okay, a little short unit. So meets and bounds, remember meets and bounds, point of beginning, township, section. Which is the school section again?
16.
16.
How many acres are there in a
6.
640.
640.
640 are in each square mile, right? So it'd be 640 times 36. A lot. I'm helping you extend your knowledge, right? So let's go back.
6 times 36.
So there are 36 sections that are each 1 square mile or 640 acres. So the total number of acres in a township is 640 times 36. That's a lot of acres. Anybody want to do that math?
23,040.
Yep, 23,040. 23,040. Okay. So lots of acres in a township. So that could be something, you know, that just make sure when you're thinking about your math, keep that in mind. Okay. Point of beginning, that's where you start, it's where you end. Okay, let's do a little math. So you need to know how to figure out square footage. You have to do this a lot. Okay. And so in looking at, and this is on the math FAQs, but 150 front feet. So sometimes parcels are priced by the amount of front footage. So think about it in regards to an urban development. So the number of front feet on Stratford Road would be what's most important because that's your prime location. So sometimes things are priced based on front feet. Front feet will always be the first number that you see, okay, or the number they tell you is the front feet. But if they don't tell you the front feet, then it's always the number that's listed first. Okay. So linear feet is when you add everything together, right? You're adding your 150 plus your 50 plus your 150 plus your 50. So if I was going to look at the linear feet of this, then I would say that I have 400 linear or running feet. 150 front feet, because you'll see that 150 close to my street there, okay? How many square feet? That's length times width. Length times width is your square footage, okay? So that's 150 times 50. You do need to know that. The other thing that you need to know is you need to know that there are 43,560 square feet in an acre. You must know that number. 43,560 square feet in an acre. There are lots of different cool ways to remember that. All right, so here are some of the cool ways to remember that. The first one is called 7-11. So 4 and 3 is 7, 5 and 6 is 11. So you get 7 and 11. Some people just remember it by 7 and 11. 7-11. Another one is if Richard Petty, who was at car 43, drove 56 miles an hour in every race, how many would he win? 0. That's another way some people remember it. And then another way I've heard it remembered is that 4 blue-haired little old ladies doing 35 in a 60. So whichever way helps you remember 43,560, you must know 43,560 for the test. Right? You've got to know it. You'll have to use it in a math problem. You'll also, they will probably ask you 43,560. They'll ask you the number of square feet in an acre, and they'll give you like 43,560, 46,530, 46,350. They'll give you a whole bunch of different numbers, and you have to know which one it is. Okay. So however you can remember 43,560, commit that to memory. All right. So lots of different ways people remember. I remember the 7-Eleven, but then I also kind of like have, it goes 4 to 3 and then 5 to 6. So it counts down and it counts up, and that's how I remember which order they go in, but that's just the way my mind thinks. But lots of people like the 4 blue-haired ladies doing 35 and a 60, or Richard Petty going 56 would win no races whatsoever.
You say the 7-Eleven one again?
So 7-Eleven, 4 and 3 is 7, 5 and 6 is 11. So you just remember, that helps you remember that it's, you know, the first 2 numbers are going to equal 7, the last 2 numbers are going to equal 11.
Okay.
That's just another way to remember it. So that's just kind of, that's how I learned it, but I've heard the other 2 since then, so I share all 3 because everybody's mind works differently. And you may just memorize 43,560, kind of like memorizing your credit card numbers or your driver's license number or social security number. You just remember it, 43,560. Okay, so to calculate the cost of land of 17,500 square feet at 60,000 per acre, you convert the cost per acre into the cost per square foot before multiplying the number of square feet in the parcel. Yeah, or let's pull this out and let's look at this on the whiteboard. So I need to remember what's the cost of, so we want to know the cost of, okay. So y'all might have to help me remember what my question is. All right, so if we have 17,500 square feet, and we know that it's costing $60,000 per acre. Okay, $60,000 per acre. So lots of different questions they can ask you. So if you have 17,500 square feet, it's $60,000 per acre. So what if they said to you, what is the 60,000, let's see, we have to say per acre. And so what is the cost of this parcel of land? Okay, what's the cost of this parcel of land? So what's the cost? Okay. So if I'm going to figure this problem out, first thing I might do is I might go, okay, 17,500 square feet, okay, and then I know that there are, and I have to get this to acres, and that's equal to how many acres? Okay, and I know that there are 43,560 square feet in an acre. So I'm going to take 17,500, divide it by 43,560. Who's sharp on their calculator and can tell me that?
0.40.
0.40. So that's going to give me 0.40 acres. Okay, and then my cost per acre is 60,000. So I'm going to multiply 0.40 acres times 60,000. And that's going to give me the cost of this piece of land, which is what?
24,105.
24,105. Okay. So what tends to trip people up here is, gosh, do I multiply or divide? I don't know what to do. All right. So here's how you kind of keep that straight in your mind. 17,500 square feet. Is that more or less than 43,560?
That's less.
Less. Okay. So if 43,560 is 1 acre, is 17,500 more or less than 1 acre? Less.
Less.
So that's 43,560, right? 17,500 is less than 43,560. So my answer's got to come out to be less than 1, correct? So
Okay.
that's how I know the 0.4 is correct, right? So I know I have to divide that way. If I divided it the other way around, right, I would have gotten a number larger than 0.4 or larger than an acre. So 17,500 is less than an acre, so I know my answer is going to be less than an acre. I've got to divide it by the 43,560. Some people tell me that kind of helps them keep it straight.
So you multiplied 0.40 times 60,000 and got 24,105.
Well, that's what my math people told me. I actually did not do the math myself.
I got
Yes.
24,000.
I got 24,000.
Okay.
Well, if you round up and do 0.40 times 60,000, then it goes to 24,000 equal. But if you just multiply,
oh yeah, if you don't round
it's rounded up.
Yeah, if you don't round up.
Yeah.
Okay.
So you really shouldn't round to the end if you don't have to, but close enough. Okay.
Say don't round, just multiply.
Yeah, you don't. If you round the whole way through, you'll end up off. So typically, our math workbook tells us if you're going to round, you go 3 places past the decimal. So I would round to 0.002. I would carry it out that far until the very end where you actually put it in dollars and cents. If the number is like 0.002156 and you don't have to retype that in, you're able to just get that number and then multiply times something, don't even worry about rounding it off, because what you're going to see on the test is they're typically don't round, or they round to 3 afterwards. Okay, until you get to the answer, and then the answer, of course, is always dollars and cents. It's the normal way of doing things.
Okay, thanks.
Okay. Mm-hmm. All right, so let's see if I can try to float by 2 things at the same time. I will just, I'll show you that on the, I'm going to stop my share here, and I'm going to share back this other screen because the slide does it a little bit differently. So on the slide, what they've actually done, whoops, is they did it a little bit differently. They took 60,000 per acre, divided it by 43,560 square feet per acre, got $1.38 per square foot, and then multiplied it out that way. Okay, so different people's brains think different ways, right? I kind of think about it this way, the way that I worked it out. Other people will think about it this way. So for me, I'm like, all right, I'm gonna do it the way that I showed you. But here's another way to do it. All right, so you can think about it either way. So I like to get things to acres because then I know the cost per acre. That's just the way my brain works. But you might want to work it the other way. It doesn't matter which way, you're going to get the same answer. Okay, so remember, calculate area, calculate square footage, calculate front footage, and calculate acreage. So we'll be doing some of those problems here after we have our lunch break. Okay. So we're going to work on math after lunch because I want to try to go ahead and get through some of Unit 5 while we're still fresh. So just at this point, what questions do any of you have on Unit 4? Anybody have a question on Unit 4 before we start looking at Unit 5, knowing that we're going to save a bunch of math for afterwards, because I think that it's easier to stay engaged in math than it is to listen to me talk after we've had lunch and people are kind of going, yeah, I'm a little bit fuzzy here, a little bit sleepy.
Okay, Jane, I have one quick question. When it comes to rounding, are we rounding as far as the decimal point before or after the answer that you get? Because what I did was I rounded after I got my answer, but it sounds like I should be rounding before I get to the answer.
I don't round till the end.
To the end, okay.
I round at
That's
the
what I
end. Yep. I try to keep it in and round at the end is what I like to do. But if you round before the end, make sure you take it at least 3 places past the decimal, or you'll end up getting numbers that will be enough off that you will doubt yourself.
Okay, I got you. Thank you.
Sure.
Jane, will we get questions on the rectangular survey system?
You will get questions on the rectangular survey system. You need to know the 640 acres. You need to know that stuff in red on the slide. The 640, you need to know 36 sections. You need to know how they're numbered. And you need to know that the school district is section 16. So you're not going to have any of the math where you have to figure out how many square feet are in a certain section of a section of a section. And you won't have to like figure out and draw out, you know, and find out which section is the right section. Is the northeast 1/4, the northwest 1/4 of the 24th section. You won't have to do that. But you do need to know the 640 in 1 square mile. You need to know that there's 36 square miles. You need to know school section, the meridians and the baselines, just know which way they run. And then they may ask you a question. I've seen this on a test before. What's directly due east of like number 7? So you need to know that the line that they laid right next to each other, right, in grids of like multiple bingo cards set right next around each other. So just that. No hard math, just basic concepts. And there may be like 1 question out of both tests that's going to be on that. So it is not a major topic.
Thank you.
All right. So let's take a look at, this is right here. Yep. 5, transfer title to real property. Okay, and this will take us up to our next break here. So, and which will be lunch. So learning objectives: identifying the methods of transferring title and the elements of a deed, calculating excise tax, yay, describing the 3 major types of deeds, and explaining the process of title examination and recordation. So this is critical stuff. This stuff is on the test. This is important stuff, but a lot of this stuff is logical stuff. And there's a little bit of math involved in this as well, right? And so we will take a look at that. I tell you what, let's do 5 minutes. Let's do a quick little stretch break here. 5 minutes, just to everybody stretch in case you need to run to the bathroom real quick, or you need to refresh your beverage, get some more hot tea or whatever. And we will let's do a little quick break here. First, I had my brain thinking we were at 12:30, but I forgot lunch is at 1. So let's take a little quick stretch break, and then we'll come back and we'll dive into this because I don't want you guys to fall asleep. Resume my recording. All right, so title. What is title? The title is the right to or the ownership of the land and evidence of the ownership. So the title is also referring to the deed. So when we talk about the deed, we're also talking about the title. When we talk about the title, we're typically also talking about the deed. This is what is representing our deep C, the bundle of legal rights. So that deep C, what does the D stand for in deep C? Bundle of legal rights. What's the D? Who knows? What's the D? The D in
disposition.
Disposition, yes, the disposition. What's one of the E's?
Enjoyment.
Enjoyment. What's the other E?
Exclusion.
Exclusion, yes. What's the P?
Possession.
Possession. And what's the C?
Control.
Control. So that's our bundle of legal rights. So remember that. If you get a question on that, you're going to have to know, like they'll say, which one of the following is not one of the bundle of, not one of the bundle in the bundle of legal rights. Okay, so that's usually you get one of those except questions when you've got that going on there. All right, so how would you transfer title? Well, one way is by voluntary alienation. Why would you ever want to voluntarily part ways with your property? Well, for a heck of a lot of money, right? A whole bunch of money. I'm going to be voluntarily alienating from my property because you're going to give me a whole bunch of money for it. Or maybe I'm going to alienate from it because I'm going to gift it to someone by deed. I had a guy who, crazy story, very first property my husband and I ever bought in foreclosure. We bought it in foreclosure. We put the people who were foreclosed on right back in it to rent it with a land contract, which we'll talk about later. And we ended up being their benevolent despot. By the time that at a certain point, they owed us at one point like $180,000. And about $100,000 of it was loans, not the house. So through a long chain of events, to make a very long story short, eventually it got to the point where they had paid enough money that I said to them, you've paid enough money, I'm going to give you the deed to the house. All right, you've paid it off. You've paid off that amount because I really did not want that deed anymore. The house was a piece of junk. It was just a piece of junk. Nothing in it had ever been permitted after the original building of it. It was, and I was like, this is just like a nightmare. Okay, so I did that, and then they still owed me $100,000. So I had that was the collateral, right? So then it was a personal loan. They owed me $100,000. The house was the collateral, and I gave them a deal, and I said, if you will pay me off in 1 year, you only have to pay me $85,000 instead of $100,000. So it'll save you $15,000. Because I figured it out that at the rate that they were paying when we were both 75 years old, they would still owe like $93,000. And I was like, I do not want this to go on forever. Okay. And so the guy did pay me off, but let me tell you how he ended up paying me off. So after foreclosure and all of this stuff and a divorce and bankruptcy and everything, he got his act back together, found a new woman. They got married very happily. And for a wedding present, her father gave them a house behind the 9th green at Colonial Country Club. So that's a gift deed, all right? And they actually had it done by a gift. So her father voluntarily alienated from his property by a gift, gave them the deed to that. And then they were able to pay me off and then eventually sell that house. And now they are free and clear, money in the bank, life is good, and they have a house behind the 9th green at Colonial Country Club. So that's a cool way to have alienation. So there's also involuntary alienation, and that is you don't really want to depart with your property, but you have to. Like this guy's first situation, he was foreclosed upon. Okay, foreclosure is the most common way, but it could also be by eminent domain, where it has to be taken over by the government. For example, when they expanded the airport, some property was taken by eminent domain. And so they still had to pay you for it, a fair price, but they got to take your property away from it, and whether you wanted them to or not. Requirements of a valid deed. This is important. Hot topic here from North Carolina. It must be in writing. The grantor must be at least 18 years of age. The grantee must be named. Adequate words of conveyance. And we'll see what those are. Accurate legal description of the property. Must be signed by the grantor. Not signed by the grantee, signed by the grantor. Person who is the seller is the grantor. Person who is the buyer is the grantee. and it must be delivered and voluntarily accepted. Now, why in the world would we say delivery and voluntary acceptance? Well, let's say that you had a piece of property in Florida. This is what my husband and his brothers owned, a piece of property in Florida, and it had been given to them in a will, right? It had been left to them, and it wasn't worth very much money. And for them to kind of change it so that they could sell it was going to cost them, change the title so they could sell it, was going to cost more than what the property was worth. So one of the things they could have done is they could have gifted it to a charitable organization, right? They could have say, hey, we're just going to give it to, I don't know, some organization in Florida, this charitable organization. But the land is a piece of crap, right? So they're gifting the deed. But the charitable organization might go, well, wait a minute, this is more of a liability than it is any kind of benefit for us. So we're not going to accept that deed. We're not accepting it. So that's why we say it must be delivered and voluntarily accepted. Alrighty, so a deed executed by a minor is voidable. A deed executed while mentally impaired is voidable. All right, so when we have these things, we have valid deed, which means it's going to contain all of the important pieces, okay? Or we could have a voidable or void deed. So let's kind of take a little, let's talk about that in a little bit more detail with this. And so when we say a minor, voidable, so you must be 18 years of age. But just because you're not 18 doesn't mean that it's invalid, doesn't mean that it's void, it's just voidable. So let's say that a 17-year-old inherited a piece of property because his parents died. Okay, and he inherited the property and he wanted to sell it so he'd have enough money to go to college, right? Because he is under the age of 18, right, he could void the contract. He could void the deed because it was executed by a minor. It's voidable, right? But most of the time he wouldn't be doing that, but that's an example of voidable. If a deed was executed while you were mentally impaired, meaning that you were drunk as a skunk or you were smoked up on weed or something like that, then it is voidable by the person who was impaired when they signed the deed. So if you were the grantor, right, then you could, the deed could be voidable. However, if you have been declared legally incompetent by a court of law, the deed is void from the very beginning. Not just voidable, it's void because they did not have legal capacity to be granting the deed. Okay, and we'll talk more about void and voidable in future chapters because that's really important stuff that we talk about quite a bit. Okay.
Hey, Jane.
Yes.
When we talk about voidable, are we talking about both for the grantor or the grantee to be sound mind or if they're impaired?
So in this case, yeah, good question. In this case, it is the grantor. It is the grantor. And so the grantor is the person who is granting the deed. They're the person who is giving the deed. All right, so that's the grantor that we're talking about right here. Now, when we talk about contracts, when we get into law, in basic contract law, we will be talking about either party. But in our first little intro here, we are only talking about the grantor. So we will revisit void, voidable, and valid in great detail in contract law, and we'll be talking about all forms of contracts, and then it will be either party. But for here, it is just the grantor because they're the ones who are executing the deed. So let's say that somebody who had Alzheimer's disease and they had somebody that was maybe a relative who was trying to hoodoo them into giving their property to someone, right? And they got them to sign the deed, but if they had been declared mentally incompetent by a court of law or been declared as having Alzheimer's disease, that deed that they granted, because they were the grantor, would be void. Okay, so right now it's only the deed, so we're only talking about the grantor. But when we get into the other part, we will be talking about either party. Good question. Other questions, anybody? Okay, what do you not have to have for a deed that you might think that you would have to have? A deed does not have to be witnessed. A deed does not have to be dated. But if it's really cute, you might want to ask it out. Just kidding. It does not have to be dated. It does not have to state the exact amount of consideration. So it doesn't have to state how much you sold it for, because it may have been a gift, right? So you don't have to state the exact amount of consideration. It does not have to be acknowledged. And by acknowledged, that is another word for notarized. It does not have to be notarized. Okay? It does not have to be signed under seal. That's like a fancy notarization, right? So it's like notarization on steroids is the way I like to think about signed under seal. Right? And it does not have to be recorded. It does not have to be those things. Now, most people think that deeds have to be recorded, but they do not have to be recorded. Should they be recorded? Yes, and we're going to learn about that. But do they have to be? No. They do not have to be witnessed, dated, state the amount of the consideration, notarized under steroids, aka signed under seal, or recorded. A deed becomes effective, okay, delivered, okay, against third-party claims at the date and time the deed is recorded. So even though it doesn't have to be, in order to be effective against third-party claims, then it must be recorded. And that is at the date and time that it becomes recorded. It also becomes protected against third-party claims. So what are the types of deeds? The types of deeds are the kind you want: general warranty deed. That's the Mac Daddy of all deeds. So that's the one that you want to have, a general warranty deed. Then we have a special warranty deed. It's kind of like watered down warranty deed. Then we have a quick claim deed, which is like, yeah, I'm just going to quick claim this part over here to you, and really doesn't have any guarantee whatsoever. And then we have special purpose deeds. And special purpose deeds might be a trustee's deed in a foreclosure sale or something like that. The three you're going to really have to know the most about are general warranty, special warranty, and quick claim. Okay, so the general warranty deed, there are certain covenants that are in the general warranty deed. And you just need to know these covenants again to be able to pick out what would or would not be a covenant in a multiple choice question. So the covenant of season means the right to convey. So you are warranting that you are the legal owner and you have the right to convey the title. Delivery of season is the actual transfer of title. So that's our first covenant. The next covenant is the covenant against encumbrances. So the grantor is warranting that the property is free from liens or encumbrances except those that are of record. Okay? So there's not some hidden encumbrance out there that's not a part of the public record. That's what they're saying there. The covenant of quiet enjoyment. So the grantor in this case is guaranteeing that the grantee's title will be good against third parties who might bring court actions to establish a superior title. And if the grantee's title is found to be inferior, the grantor could be in hot water. So that's the covenant of quiet enjoyment. It means you're going to get to enjoy your property without other people coming after it. The covenant of further assurance says that the grantor is going to promise to obtain and deliver any instrument that is needed to make the title good. For example, if an error in the deed is found, they're going to get a new deed so that you have, exactly what you need. So that's further assurance. And then warranty forever says that if at any time in the future the title fails, the grantor is going to compensate the grantee for the loss that is sustained. Okay. Now, it is still in the best interest of the grantee to get title insurance. Title insurance. The lender will require it, but you should also get an owner's policy. Okay. So this is the best deed for the grantee. It's the worst deed for the grantor because it gives them the most liability, but it is the most common deed that we see in real estate transactions today. Okay, so that's what you're going to have, a general warranty deed. All right, so here are those exact words for the covenants, the different covenants. All right, if you want to see that again, I kind of talked about them, so I'm not going to read them to you again, but that's where I was getting the language from, was from this slide. Your special warranty deed, that's warranting that the grantor received the title. And it's warranting that the property was not encumbered by the grantor. Usually this is going to be associated with foreclosure. So a special warranty deed says, I'm warranting this property for the time that I owned it. I'm not going anywhere back before that. I don't know what happened before that. I'm not guaranteeing it before that. I'm just doing it for the time that I owned it. All right. Sometimes that's called a limited warranty deed. So you're just, doing it for the time that you own it. So your little words of conveyance may be different. You may say the words remise, release, alienate, and convey in the granting clause. Okay, but you typically don't. I'm not going to ask you that, but just in case you were wondering. So it's not quite as much. So your general warranty deed is taking it back forever. Okay, special warranty deed or limited warranty deed, just in the time that the grantor owned the property. Bargain and sale deed, in case you hear that, no express warranties against encumbrances, did not even imply that the seller holds title or possession. Very similar to a quitclaim deed. So quitclaim deed is what you're typically going to see in North Carolina. Bargain and sale you may see in some other places. So that's kind of an iffy deed. Our quitclaim, okay, is a non-warranty deed. No express or implied covenants or warranties. All right. So there's nothing, and it's usually used. Yeah, let's get used in there a bunch of times to cure a title defect or to transfer title very, very quickly. So here's an example. I had a client who owned a house, and she owned a lot with her sister. And when it came time to sell the lot, it all needed to be in my client's name. So her sister quitclaimed her part of the lot over to my client so that it could be easily sold. And then they just figured out the finances between them. Another time when you might see a quitclaim deed used is when spouses are divorcing and the separation agreement says that the wife is going to have to sell the house. And so the husband will quitclaim his part over to the wife. She sells it. And then the separation agreement determines how the proceeds are going to be split up. And it could be the other way, that the wife has to quitclaim it over to the husband, and the same thing there. So that's typically where you see a quitclaim deed, right? It could also be used to clear up an incorrect name on a deed, to fix something like that, fix something that's that's incorrect on a deed. You might see it in that case. Right? So those are the three that you mainly need to know about. You need to know general warranty, special warranty, also known as limited warranty, and quitclaim. Those are the ones most likely to be on the test. Now there are some others. There's a correction deed. That's another thing you can use to correct something that's wrong with the deed. The gifting deed, we talked about that with my friend that was gifted a whole house on the golf course. A deed of release. So you're going to see that when you've paid off your deed of trust, right? You're being released from that. And so that's going to be recorded that you've paid off your mortgage, also known as the deed of trust. And so, so that's in a part of the public record. Okay. A trustee's deed. That's kind of when a trustee is going to be selling it. So that would be in a will. It could be a part of a trust agreement. You would get a trustee's deed from that. So you also might see it at a foreclosure when the trustee is selling it. Okay. So we might have a timber or mineral deed, and that would just be a deed to timber rights or mineral rights. Okay. And then some deeds that would be executed per court order. And so those will be like a sheriff's deed or a tax deed or a guardian's deed, executor's deed, those types of things. So they're pursuant to court order. So those are just special purpose deeds, not typically on the test, just need to generically know those. So yes, so somebody was saying about the quit claim. I guess when the spouses quit claiming over, that's when they both own the house together. And so one would have to quit claim their part over to the other one. Yes. So involuntary alienation. If you die without a will, you die intestate, right? And you have no heirs and you have no will, what happens to your property? It escheats to the state of North Carolina. So the great state of North Carolina is going to get your property back. That's why you need to have a will or you need to have heirs, preferably a will or a trust or something like that that says what's going to happen to your property after you die. Because if you don't have it, you don't have heirs, and the state's going to keep it. Another way you could lose your property is through eminent domain. So this is when the government can take private property for the public good. The process of doing that is called condemnation. So when you see that something has been condemned, sometimes that means that it's unsafe to live there. And so it's been condemned. But other times it means that eminent domain is occurring and it must be condemned as a process of taking eminent domain. Just compensation must be given. They can't just take it and not pay you for it. They have to give you fair market value for it, right? And if eminent domain is taking a leased property, that will terminate the lease of the person that's there. So they can't stay there with their lease after it's been taken over by eminent domain, okay? So the last way that you might alienate from your property would be foreclosure, would be a lien foreclosure. And we will talk about foreclosures in detail in Unit 14. But just know that's another way you might involuntarily alienate from your property. So escheat goes back to the state because you died without a will and without heirs. Eminent domain, the government is taking it for the public good. They must pay you for it. The process is known as condemnation. So you need to know the difference between condemnation and eminent domain. Okay, so that's something they might ask you on a test. So condemnation is the process by which property is taken by eminent domain. And then lien foreclosure. And like I said, we'll talk about that in more detail in Unit 14. Adverse possession. So we talked about oceans when we were looking at an easement, right, that was a prescriptive easement because people had been using it notoriously and adversely and openly for a set number of time. So we can also have kind of like all pieces of property taken that same way, adverse possession. Okay, adverse possession is persons are taking ownership of a piece of property, not just an easement, but a whole piece of property. So they must have some reason to believe that it's theirs. Okay? Owners who don't use their land for a number of years can lose the title to their land to another person who's making claim to the land, takes possession, and most importantly, uses the land. So you need to keep check on your land or you can actually use it. That's a really weird thing that we have left over. You would think once you own the land, you couldn't lose it, but you actually can. So for you to have adverse possession, that person must have been taking your property for 20 years. Right? And open, continuous, exclusive, adverse, and notorious. So you haven't checked on your land for 25 years, and what you found out was 24 years ago, somebody built a house on it and they've been living there continuously for the past 24 years. Guess what? They took your property through adverse possession. Okay? And you didn't know it. So that's what adverse possession is. Now, it doesn't happen very often, but you do need to know what it is. Go ahead, question.
I'm sorry. Is this just in North Carolina, or is this in every state, or is it different in every state?
So some of the requirements for it could be a little bit different in different states, but in North Carolina, the required time period, okay, the statutory period is 20 years. However, if there's a faulty title, then it could be 7 years.
Wow.
And property owned by the government is not subject to acquisition by adverse possession. So if the state of North Carolina owns something, you can't go take it away from them. All right, so just so you know that. So, so we're typically talking about how this works in North Carolina.
Okay.
For this, but it could be anywhere, and things are going to, vary based on the circumstances.
All right. Thank you.
Mm-hmm. So, what happens to a deceased person's property? Well, hopefully they have a will, in which case it's easy. Transfer of title is by the will. Now, if it's a spouse and they own it by tenancy or by the entirety, then it's automatic. It goes to the other spouse. But if they die without a will, we go through a process called intestate succession. And that is where the state is determining who is going to get it, okay? And this is done by descent. This is done by descent. So it's going to be an equal division of property among eligible heirs. Or in the event of no heirs, then the state gets it back, all right? And so that's just what it's called. It's called by descent. So the gift of real property is known as to devise property. And the person who gets it is known as a devisee. Devisee. So the term, typically, if you're getting personal property, you're a beneficiary. If you're getting real property, you're a devisee. All right? But in North Carolina, sometimes we use devisee to mean personal or real property. Right? And that's just like FYI thing. Go ahead.
So this takes place before escheating?
Yes. So if you die without a will, the first thing that happens is intestate succession. So the state of North Carolina is going to look and see if you have heirs. And if you have heirs, then they're going to divide up your property on the laws of descent. Okay, intestate successions. There's a formula that they use to divide it all up. If you have no heirs and they cannot find any, okay, then it will escheat back to the state. Okay, so there's this really cool Hallmark movie called All of My Heart, and they actually had like 3 movies of it. But the premise of it starts out in that this girl and then this guy, and in the beginning, of course, they don't like each other because it's a Hallmark movie. You know, they hate each other at the beginning, they're gonna fall in love at the end, right? They have both inherited 50% of an inn, 50% of this lady's house, because she died intestate, and they were found to be heirs. They were found to be heirs. So the state will search out any way to find the heirs and devise the property to the heirs, all right? And if they cannot find any heirs whatsoever, then it will escheat back to them. Okay? But many times they can find the heirs. And I think these were like the daughter of the cousin of the whatever, you know, so it can go pretty deep. It's not just no children, right? So it can look then for sisters, and it can look for nieces and nephews and that kind of thing in order to find the heirs. But they're not going to test you on that level of detail. You do need to know intestate, dying without a will. You do need to know escheat back to the state of North Carolina without any heirs whatsoever. Any other questions about that? Okay. Public records. So we need to know about recording of the deed. Recording of the deed is going to give notice, okay, that transfer of title has occurred. All right, so we're going to talk about notice, priority, unrecorded documents, okay, and the chain of title. So recording. This is giving legal priority to interest recorded first. First in time, first in right. So North Carolina is a pure race state. That means, sounds like kind of like that's like an off, you know, like really, we're a pure race state. That sounds kind of bad. But what that means is we're actually running a race. It's that kind of race, not the other kind of race like we talk about in fair housing. We are running a race to the courthouse. And the first come is first served. Okay? First come, first served. And I will say the people that created this slides do not know the difference between principal and principal. So this should be the principal PLE, not PAL. I'll have to correct that. So the principal is your pal, like the principal, the person, you know, and then the principal is the EL is the principal. So they misspelled principal here. So please do not, you know, count off for them on that. But anyway, so first come, first serve. That's why we were talking about that mechanics lien. It goes back to the first day that the materials were delivered or labor was done, because first come, first serve. They want to get that lien recorded. So we want to get that deed recorded. So first in time, first in right. So you could actually lose a piece of property if you did not record the deed and somebody else recorded the deed to it. And again, lots of attorneys will be involved in that. But that's the importance of recording. It gives legal priority to who recorded first. Notice, we have two types of notice. We have constructive notice. Okay, that is the legal presumption that information may be obtained. And then we have actual notice. Information is available, the deed is recorded, and serves as public notice of interest in real property. Right? So that's what's important, is our actual notice here. That's what we want to have. All right, the information is not only available, but somebody's been given the information and knows it. Direct knowledge, it has been recorded. Priority, that's going to refer to the order of when documents or liens were recorded. Okay? So we always, that's why we have that mechanics lien, and talking about first come, first served. Unrecorded documents, okay? Now remember when we were talking about the taxes and how that lien goes on your property on January the 1st, but you're not delinquent until the following January the 6th? This is what we're talking about right here. Tax liens and special assessments are not recorded until they're past due. So on January 1, every single person that owns property in Winston-Salem did not have a lien filed on their property, right? It was not recorded. It was not filed. It was not recorded. It's not going to be recorded until it's past due, which would be next January the 6th. So if you are past due, that's when a tax lien or a special assessment is going to be recorded. So even though the lien's on your property, we're not recording it until you are past due. Okay? So that's a little interesting little factoid about that. Chain of title. So this is what the attorney does when you are getting ready to buy a house. They go and they look at the chain of title. So an unbroken chain of title is traced through linking the conveyances from the present owner back to the earliest recorded owner. So so-and-so sold it to so-and-so, sold it to so-and-so, sold it to so-and-so, sold it to so-and-so. Oh, here we are, now we're where you're buying it. Okay, except they go in the reverse order. So it goes from the grantor who's granting it to you, to the person that granted it to them, to the person that granted it to them, and they check back forever which in the state of North Carolina is 30 years. So it's got to be at least 30 years in North Carolina. And if things are clear for 30 years, they assume it to be clear before 30 years ago. So it must be at least 30 years in North Carolina. That's a hot topic to know that they must check back for 30 years, not 10, not 20, but 30 years to go with the chain of title. Title assurance. Title assurance. 5 criteria to have a marketable title for the conveyance of real estate. Okay, real property. Free of significant liens of encumbrances. Okay, so we know that the seller may have a mortgage, but they're going to have to pay off that mortgage. So that's not going to count, right? So, but significant liens otherwise, things that aren't going to be paid off. So it needs to be free of significant liens and encumbrances. No serious defect in the title. We know exactly who owns it. There's no question about that. Right, so we want to make sure we've got that going on. We want to have no questions of law or the fact that it's valid. We want to make sure that it's going to be valid, meaning that the person who is granting it has the legal capacity to do so. The promise of quiet enjoyment to the grantee. Okay, so we've got to remember those covenants. That's why we go with the general warranty deed. And be reasonably assured of fair market value. Reasonably assured of the fair market value. All right. So the reason we got in trouble back in 2008 is because people were saying that the fair market value of pieces of property was way more than what they were. And they were just trying to do anything they could to get people loans. And they were given loans with all kinds of ridiculous terms and things that people had a graduated payment. In the first year, it was $500 a month, and they could make that. In the second year, it went to $2,500 a month, and they were upside down, and all kinds of crazy things happened. So, so those things don't happen anymore. But just keep in mind 5 criteria for a marketable title. Not super important. This is just a green topic, but just something that actually does make a lot of sense as to what you would be thinking about. So, title assurance. The best title assurance is title insurance. Okay. So we have a title search. So that's what the attorney does. He does the title search. And then you get title insurance. You should never purchase a property without title insurance. Never. You need to have title insurance. Never purchase it without title insurance. And then title recordation. Okay. The necessity for recording is so you get protection from third parties. Because you want to have that protection. That's giving that notice to everybody. Hey, I own this piece of property and you cannot have it. Right? And so then we have the Connor Act. And so the Connor Act is very important with regard to title assurance because it requires that most real estate documents be recorded in order to be enforceable. So that deed has to be recorded in order to be enforceable. That lease of over 3 years has to be recorded in order to be enforceable. That deed of trust has to be recorded in order to be enforceable. Okay, so Connor Act. Remember the Connor Act, North Carolina requires real estate documents to be recorded in order to be enforceable. So the abstract, when the attorney does the title search, he is doing an abstract. So he is kind of like preparing if you've ever read journal articles, there's an abstract. It's kind of like a summary of all the important stuff in the article. So this is like a summary of all the important things about the title. Right? And so then sometimes we'll have what's known as an actioned quiet title. And it's a lawsuit. It's brought in court, right, in order to establish a party's title to real property. Okay. So, so what it's doing is it's quieting any challenges or claims to the title. So just remember that an action to quiet title is a lawsuit brought in court, okay, having jurisdiction over property disputes in order to establish a party's title to real property having a title of against anyone and everyone, okay, that might be trying to challenge the claim to the title. Therefore, it quiets those challenges. So that's just kind of like a definition thing, but an action to quiet title. That's one that they like to ask you about. So your action to quiet title is just to, take care of anybody that might want to challenge the title. Excise tax, more math. Woohoo! This is really fun. We'll do this. We'll actually do math for this after lunch. And this is easy math. And the cool thing is that this is super easy math, and it is definitely on the test. So never should anybody miss this. Excise tax, you do need to know it's paid by the seller. Okay. The only time it's not paid by the seller is if that's something that's been negotiated in the contract. Okay. Sometimes we call it transfer tax. So you do need to know the word transfer tax. It means the same thing as excise tax. You might also hear it called revenue stamps. That's more of an old-timey term for it, but know that all three of those things mean the same. Excise tax, transfer tax, revenue stamp. The rate is $1 per $500. And it's calculated on the full purchase price. And it's always a whole dollar amount. So earlier today, somebody asked me about rounding. When you're doing excise tax, you always round up. So let's say that the excise tax came out to be $161.01. The excise tax would be $162. You always round up. And that's easy to remember because this is tax and the government's always going to get the maximum amount of money that they can from you, right? So that's how you remember that. So it's always calculated on the full purchase price. So if you bought a house, let's do one real quick. You bought a house for $250,000. What would the excise tax be? Excise tax on $250,000.
$500?
It would be $500, exactly. So what would the excise tax be on a house? $260,000.
$520.
$520, exactly. Okay, so let's say that the sales price was $216,000, $216,454, $216,454. What would the excise tax be on that?
$433.
$433. Yep, so it's 432.908, so we're going to round it up to 433. Okay, so you always round up if it turns out not to be a whole number. So here's an example right here. 249,750. 249,750 divided by 500 is 499.5. You round up to the whole dollar amount of 500. Super duper easy math. That is on the test. That's on every test you're going to take. You're going to probably have one of those. So that's a math. There's one that you know you're going to get right, right? All you got to do, remember, divide by 500, round up. All right, so here we go. Let's do a little practice question here right before lunch. Essential elements of a valid deed include all the following except. So remember, 3 of these are going to be like true, one's going to be false. Okay, and so you've got to know which one does not match. Which one does not match?
A.
So must a deed be in writing? Must it have a competent grantor? Must it be executed by the grantor? What is acknowledgement? What does that mean? Remember?
Recording.
Notarized.
Notarized, yes. Acknowledgement means notarization. Does a deed have to be notarized?
No.
No.
It's not. So true, 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 and one false. So the one that's false is the one that doesn't fit. Okay. So just keep remembering that when you are thinking about your logical reasoning. All right. So acknowledgement is required to be recorded. Signature of the grantor is voluntary and witnessed by a public official or notary public. So here's like a little tricky thing. So don't let this mess you up. All right. Acknowledgement's required to be recorded, but it's not required for a valid deed. Because remember, a deed doesn't have to be recorded in order to be valid. It has to be recorded in order to protect you from challenges against third parties. Okay, so that's the difference in that. That's the difference in that. That's a little tricky point there. All right, but that one will get you on that. All right, so key terms. Know the Connor Act, which requires most documents related to real estate to be recorded. That's the Connor Act. Know the general warranty deed. That's the Mac Daddy, okay, with all those different covenants. The grantor is the person, typically the seller. The grantor is the seller. They're the person who signs the deed. The grantee is the buyer. They're the person who's getting the deed, right? They don't sign it. Adverse possession, remember that. Oceans, you have to remember oceans. Adverse possession, 20 years. Cloud on the title. Okay. Quitclaim deed is typically used to clear up a cloud on the title. And then remember your math. We're going to practice that after lunch. So let's take our lunch break now. I'll see everybody back at 2 o'clock. And we will look at, we've got 2 fun chapters to do, especially 20 short, fun, and easy. And so you're like that. And then we're going to do a lot of math this afternoon as well. That'll keep everybody awake in the afternoon after you've all had a lunch. So enjoy your lunch break, and I will see you back at 2 o'clock. Thought we'd mix things up a little bit, do a little math, then do a little bit of units, and then probably do a little bit more math, and then do some review and some breakout groups. Kind of keep things hopping this afternoon. So let's start off with a little bit of math. And so we're going to be looking actually at page 83. So if you will, turn in your books to page 83, and let's do a little bit of math relating to length times width, you know, some acreage stuff, some square footage stuff, and some cost for things in that regard. So let's take a look at number 15. Let's start off with number 15. So give number 15 a whirl, and then we will work it out together. Okay, so I'm starting to get some answers in. So that's pretty cool. People are answering. So who wants to walk me through this problem? How did you do it? Who can do that today? Did you start?
Okay, I will.
Go for it.
Okay, so what I did was I divided 21,780 by the acreage amount of 43,560.
Okay.
And that total, let me go back to it. I got 0.5.
0.5 acres. Okay.
And then I multiplied that times $25,000 per acre.
Sure.
And that gave me the 12,500.
Okay. And that gives you 12,500. Okay, any questions on that? So I find it easier to convert things to acres if they're giving you the price per acre. That's the easiest. Okay, all right, great. So let's look at, we're gonna skip number 16 for now. We're going to look at that when we do construct square footage. We'll talk about some square footage measurements in houses and things like that. So let's look at 17. Look at 17. 17's tricky. Take a look at 17. Getting all kinds of different answers on this one.
The D.
All right, this one is, yes. Somebody got the right one. Yes. Dylan, I think you have by default become the person who needs to tell us how to answer this question.
Oh, wonderful.
I'll help you. I'll help you.
So first thing I did was convert the feet into yards. So for the 12, it was 4 yards.
Okay.
And then the 14 feet I converted into 4.6 yards, which gave me 18.67 yards.
Okay.
I then multiplied that by 2, which gave me 37.33.
Right.
And then multiplied that by $25, which gave me $933 and some change. So I rounded up to $934.
134. Yep. So okay. So what you did is exactly right. Okay, you did it exactly right. It was interesting how you went about it. There's a couple of different ways to do it. So you converted your square feet to square yards first. Okay. And
exactly.
That's definitely one way to do it. Another one is to get your total square feet and then put that in square yards. So I'm just going to show that as a little bit different way to do it. So if we have our room, we know that it's 12 by 14. And so 12 feet by 14 feet is going to be 168, okay, square feet, right? So if we're going to convert square feet to square yards, we must divide by 9 because there are 9 square feet in a square yard. Okay, if you don't believe me, Google it. All right. So we divide that by 9, and that gives us 18.67, okay, square yards. Right. So 18.67 square yards, right? Times, so then we can say 18.67 square yards, okay, times, and then it was, what was it, $25 per square yard? $25 per square yard, all right? And that's going to give us 466.67, but there are 2 rooms, so we have to multiply that times 2, and that gives us the 934, all right? So that's kind of how we come up with that. Now, you could have taken your 18.67, multiplied that times 2, and then done your times 25s, totally fine. Or you could have converted your square feet to square yards first and then multiplied it out. That's totally fine, okay? So when we think about this, you might actually think about it like, oh, 12 square feet, all right, 12, all right, so the 12 square feet, that's gonna be, okay, divided by 3, it's gonna be 4 square yards. So you may think about it like that. And if you think about it like that, it's okay to convert it in whichever way makes sense to you. But the key thing is that you've got to get your square feet converted to square yards. And then remember, there were 2 rooms instead of 1, okay? So that's kind of the tricky part about that. Questions about that one? That one was a tricky one.
I have a question.
Yes.
Is this the only thing that we have to worry about converting, or do we have other stuff?
There will be stuff that you have to convert along the way, but this is like acres to square footage, square feet to square yards, knowing length times width, 1/2 base times height. Those are your main formulas related to this. Now, will there be a measurement question? Yes, there'll probably be one measurement question that you'll have to do length times width, or you'll have to do 1/2 base times height, something like that. So there'll probably be one of those on the test. Not a lot of conversions, just maybe 1 or 2.
All right, thank you.
So now let's look at number 18. Look at number 18. See what you get for that one. Okay, so people are coming in pretty quickly on this one. Getting lots of B's here. Okay, getting lots of B's. And so as it looks like we're getting most everybody to come in, who wants to work this one for us? Who can tell me what to do with this one? Any volunteers?
Okay, I will again.
Okay, hey, you're going to be the one who aces the math, right? Because you're putting yourself out there. All right, here we go.
Okay, what I did was I took the number of the acre total of 43,560, divided it by 2, and then multiplied it times 2.15.
Okay, so 4360 times 0.5, or 4360 divided by 2, those are the exact same thing, right?
Okay.
And so that's going to be half of that. So what is that number? 20 something.
It's going to be 2180.
21.
Wait a minute.
780.
21,780.
Yep, 21,780.
Okay, 21,780. That's your square feet in a half an acre, and then you multiply that times your 2.15, and that gives you your 46,827.
Yep.
Okay. So that's how we do that one. Cool. Questions about that one? Seems like everybody was getting that one. Okay. Let's look at another one. Let's look at 21. I don't want to give you all of them because, you know, you got to have something to do for homework. So let's look at 21. So you have to know which number is a front foot. Which number is the front foot?
125.
125, that's right. So if the total price is $64.68.75, what price did you pay for front foot? All right, so you're going to take this number and do what?
Divide by 125.
Divide by 125. And when you take that number and divide by 125, you get
51.75.
you get 51.75. Okay, so the key thing there was remembering about front feet. Remembering about front feet. And that it's the first number, and then you just divide it out. Cool. All right, we'll save a couple of those for homework. And so let's flip over to the end of Unit 5. And we're going to be on page number 107. Let's look at number 19. Number 19. So excise tax, this is a pretty easy one. Now I still recommend, even on the easy ones, I still recommend that you write out your work and don't just punch things into a calculator, just because you got plenty of time. You might as well be sure of what you're doing. So for this one, somebody who hasn't walked me through a problem yet, who's going to take a chance? Okay.
I can do it.
All right, go for it.
So we take the total price, 75,000, divided by 500. And the answer will be 150.
150. Okay. Now, what if this had come out to be 141.01? What would the answer have been then?
142.
142. So we always round up. Okay, this is the one time that you always round up. And if you need to remember that, think tax. Oh, the government, they're not even going to give me a penny break, right? They're going to want all their money. So instead of giving me a penny off, they're going to take 99 cents more. That's the way you remember that about the government. Okay?
I have a quick question.
Yes, sir.
If the price was 75, like say 75,250, would you round that up to 75,500, or am I reading that wrong?
Okay. So what I like to do, the way I do it is I do 75,250 divided by 500 and get that number. And so if you do 75,250 divided by 500, what do you get?
150.5.
150.5. And then I know, okay, anytime I have anything left over, I have to go up to the next number. So I get 151.
Okay.
That's the way. Now there's a school of thought that says you go ahead and you take your 75,250 and round it up to 75,500. Then you're dividing it by multiples of 500. I find that for some people that's confusing.
Okay.
It's easier for them to just always remember divide by 500 and know I can't have anything to the right of the decimal. And if I do, I round up to the next whole number.
Gotcha.
Okay, so I know exactly what you're saying, and yeah, but sometimes it's trickier for people to remember that than it is to remember to just round up.
Gotcha.
What page are we on?
That was on page 107. That was on page 107. We did number 19 on page 107, and then we just had a question out of the blue, and so we just answered that question out of the blue. So that was an actual problem.
Page 102, reading the first couple lines of calculating North Carolina excise tax. So
okay,
that's what was.
Yeah, so he was referring back to one of the things in the 102, kind of like how they go through it, as to how you calculate it. Okay. So there are different ways that it can be calculated. I just find this causes less confusion. And I've had people that were trying to do it the other way that couldn't ever get it right. And then once I showed them this, they got it right all the time. So I tend to, but either way works just fine. But I tend to show this one more just because I've had more success with students using this one.
Yeah, I see why now.
Okay, cool. All righty. So any other questions from anyone? We'll do some more math later, but any questions?
I kind of have a question, being that I do the real estate every day from a legal aspect.
Okay.
The validity of the deeds, with it not it's not required to be acknowledged or sealed in order to be considered valid. Well, that leaves you wide open for anybody to, you know, come and contest your ownership to that property. So why would you even consider doing that?
Well, there's a difference in whether, did I spell Connor right? C-O-N-N-E-R or O-R, you know, because there's two different ways to spell Connor. And as I did that, I was like, I don't know about that. So, so anyway, this is why we have the Connor Act in North Carolina. And so there's a difference between, it's O-R, yep, so it's that Connor. So it's the difference between being valid and being enforceable against a challenge from a third party. So it truly, legally speaking, to be a valid deed, those things are not required. But to be recorded and therefore enforceable, or to be enforceable, the Connor Act requires that it be recorded and acknowledged and those types of things. So that's how you get, and you're exactly right. You're exactly right in that if it's not recorded, okay, it's not enforceable. It may still be valid, but it's not enforceable against the challenge of a third party. So the Connor Act requires recordation of most real estate related documents in order to be enforceable against third parties. So there are a difference between being enforceable, meaning that you can take it, you know, to court. Yeah, I'm just misspelling things. I'm talking while I'm writing. It's not a good thing. So Connor says that it must be recorded to be enforceable. That's entirely different than being valid. It can still be valid, but it might not be enforceable. For example, I could say to you, I got a 2020 Subaru Forester Touring that I will sell you for $500. Will you take it? And you can say, yes. Would that be a valid agreement? Yes. Would it be enforceable? Could you take me to court and say that, you know, I needed to sell you that? No, because it was not in writing. Okay. So the Connor Act is going to require that these things be in writing. Okay. And they be recorded. And recording means that they have to be notarized or acknowledged. Okay, so you got to have your notary going on with this in order to be enforceable. So in order to handle a challenge from a third party. So that's different from just being valid. But you're right. It's got, in order for it to hold any weight whatsoever, you got to have it in writing. You got to have it acknowledged, aka notarized, and it's got to be recorded. Did that help at all?
Okay.
Yeah. Cool. Other questions? Anybody? Okay. With no questions, then we are going to look at Unit 6. And Unit 6 is going to be all about land use controls. All right, so this is the last time you see my review about the highlighter key. It ends with Unit 6. Okay, so you don't have to look at this anymore, but just as a reminder about our key. Okay, so land use controls. This is good stuff here. So in this, we're going to talk about public and private land use controls. We're going to talk about development, zoning regulations, building codes. We're going to describe land use controls and your responsibilities as a broker for disclosing those types of things. And then we're also going to explain just the master plan concept. Okay, so that's what we're looking at in this. So again, we're starting on page 109 with this. Remember, that's in the bottom right-hand corner, 109, and that's land use controls. Land use controls. Okay, so first we get to talk about police power, and this is public land use controls. So the use of police power to protect the public health, welfare, and safety. And so these things are planning, zoning, subdivision regulations, building codes, and then environmental protection legislation. Okay, so those are police power, which is basically stuff that the government can do, right, to help us stay healthy, safe, and for the public welfare. So planning and zoning. So an example of zoning is that if it's zoned residential, okay, you can't just go put up some industrial plant in your backyard. So you have to follow the zoning ordinances for your area. Okay, so master plan. So when we think about a master plan, the city of Winston-Salem, Forsyth County, Guilford County, city of Greensboro, every town, city, county, whatever, has a master plan. And that master plan is helping them to determine the use of the land, what public facilities are needed, how is traffic going to flow, how do they conserve natural resources so that we don't completely destroy the planet, okay? And then how do we abate noise abatement. I had a client the other day, oh my gosh, she was looking for a 2-bedroom, 2-bath, 1-level townhome with a garage, okay, that needed no updating. We found one. It was perfect. It had everything that she wanted. The only thing she would have done is probably change the carpet and given it a fresh coat of paint. Everything else was perfect in it. Except when we're in the house and we're looking in the house, we're saying, what is that noise? And it was cars driving by on the road. You could actually hear it inside the house. That was a deal breaker for her. She's like, no, this is my retirement home. I don't want to hear cars zooming by outside my door all the time. She said, if this house had been 4 houses over there in the middle where I couldn't hear the noise from the street, I would have sold. I would have bought it. Sorry, I would have bought it, not sold it. I would have bought it. So that's one of the things that we need to remember is that that master plan is important, and we have to think about. Sorry about that. I have a barking dog that I have to get out. So that noise is important. So think about noise abatement as a part of our master plan. We don't want to be messing things up because things are too noisy. Okay. So general zoning classifications. Generally speaking, and of course you don't have to memorize this map, you just need to know general concepts here. Residential, commercial, industrial, and agricultural. So if it's residential, you can't do commercial things on it. If it's industrial, you can't do residential things on it. If it's agricultural, you can't do commercial things on it. Okay, those are your different general zoning classifications. And when you look at a zoning map, then you will see the different classifications, how things are zoned, and kind of what all of the different numbers are. Fortunately, you don't have to know it to that level of detail. So zoning ordinances. The purpose of a zoning ordinance, okay, is to regulate and control the use of land and structures within zones. Like you can have low density residential, high density residential. You are controlling the use inside that zone. Right? So you have to think about that. And then there is no statewide standard for this. This is something that's done locally. So it's done locally in Winston-Salem, in Greensboro. Okay, it's local in nature. Then we have extraterritorial jurisdictions. Extraterritorial jurisdictions, that sounds really fancy. Did anybody look up, does anybody know what that term is? What is an extraterritorial jurisdiction? Anybody get a chance to read ahead? Sounds like ET to me, phone home. So an extraterritorial jurisdiction, so you know, is not inside necessarily the city limits, right, but still subject to the zoning restrictions of that municipality. Right, so you're just outside the city limits, but you still have to follow those zoning restrictions. Zoning ordinances cannot violate property owner rights, and you as a broker must disclose zoning as a material fact. I'll give you an example. A few months ago, there was a big debate over zoning on Bolton Street in Winston-Salem, right before you get to I-40 and it becomes Burke Mill. And there was a house there, and the people who lived in the house had died, and their heirs wanted to sell the house to PreLicensing. And in fact, the owners had said that it could be sold to PreLicensing after they died. PreLicensing wanted to buy that house and tear the house down and create another entryway to their complex there so that they could expand in the future and use that as a back entrance for employees and parking. So that would be a change in the zoning from residential to commercial. And they had to, and so there was a big debate going on about it, all kinds of things going on. And there were people that were against it, and there were people that were for it, right? And the city master plan kind of was for it. So the ultimate thing that happened was PreLicensing won, it was rezoned, they bought the house, they've already torn it down. Okay. Now, if you were getting ready to sell or buy a house that's going to be impacted by that change, right, then you would want to know that. You might not want to live there knowing that the traffic was going to potentially increase, right? Or you might not want to live off of London Lane because now that's going to really be a cut through. People are going to be using Newcastle and London Lane to cut through. So as a broker, and you know that that's going to impact things, you need to make sure that your client is aware of the change in zoning. They can determine what it means to them, but you have to let them know about that zoning. Not letting them know about a change in zoning that could impact their decision will get you in trouble with the real estate commission if they file a complaint. Okay? So you just have to, now you're not supposed to know everything, but you're supposed to know major things. Like that was a big deal. There were signs everywhere. So not knowing that would have been reckless. Okay, it would have been a violation of reasonable skill, care, and diligence. Right? So you should have known that. And so, but if you weren't certain about things, you always say to your client, contact the planning and zoning at the city so you can find out all of the details about this zoning change and how they might impact you. You don't have to tell them how it's going to impact them. You don't have to pretend to know everything. You just have to know that there's a change and help them find out the correct answer for themselves. Okay, so that's your responsibility with regard to zoning ordinances.
Jane?
Yes.
Would you mind going back to that slide?
There we go.
So what is must not violate property owner rights? What does that mean exactly?
Oh yeah, must not violate property owner rights. So zoning ordinances cannot violate your rights as a property owner. So for example, if land is taken for eminent domain, the owner's got to receive fair compensation. It's fair compensation. It's getting late. I've been talking for a lot these past 2 days. So when downzoning is occurring in an area, for instance, when land zoned for residential is rezoned for conservation or recreation, the state's ordinarily not responsible for compensating property owners for any resulting loss of value. However, if the courts find that a taking has occurred, the downzoning will be held to be unconstitutional attempt to use the power of eminent domain. So that's kind of like you're violating their property rights, all right, for that, because you have to provide fair compensation to an owner. You can't just go use some little thing to get out of having to pay a property owner fair compensation. So it needs to make sure that it's not violating their rights. And another way of that is that it needs to be applied uniformly in a similar manner, not something that is against one property owner in favor of another. So you want to make sure that it's just not arbitrary, it's not capricious, but that it's meaningful and that it is not impinging on anybody's rights. Does that kind of help?
Yes, thank you.
Okay, cool. So, a legal non-conforming use. These are important zoning terminologies. Legal non-conforming use. And so this is like on the text. So, legal non-conforming use. You own a gas station, right? And now that area has been rezoned as residential. They're not going to make you tear down your gas station, right? You have a legal use of that gas station that you own that is non-conforming, meaning that it does not conform to the new zoning, but it's been grandfathered in. So that's what legal non-conforming is. Legal non-conforming. Now, what happens after the rezoning has occurred and you decide you want to sell your gas station? Can the new owner use it as a gas station? Maybe. But the ultimate goal of legal non-conforming is to get it to where it is conforming, right? So maybe they can use it as a gas station, but they can't put in new pumps, or they can't upgrade. They can't update something, because the ultimate goal is to not keep it as a non-conforming use, but to get it to where it is a conforming use, right? So that's just kind of, they can't make you tear it down right now, but ultimately it needs to conform. So let it be grandfathered in, but they will not let it, be updated or enhanced so as to continue that non-conforming use. It can also be an illegal use, right? So let's say that you have a place that is zoned and says that there cannot be a business in the home, and you're running your massage parlor out of your basement. That would be an illegal use. So it has to make sure that it matches what the zoning is. For example, let's say that it's single family only, and you convert your house into a triplex. That would be an illegal use. Okay. The next type is conditional use. Now, conditional use is always something that is for the good of the community. So let's say you have a very large area, or even just think about going down Bolton Street in Winston-Salem, or going down Knollwood. Out right in the middle of Ardmore is St. Timothy's Episcopal Church. Well, that definitely doesn't fit, residential zoning, but it's a conditional use permit. So it's something that's going to benefit the community. A church could be an example of a conditional use permit. A school could be a conditional use permit. A hospital could be a conditional use permit. Something that's in an area, doesn't really match the zoning of the area, but is for the benefit of the people in that area. Right? So that's conditional use. Then we have variance. So variance is also something that's typically on the test. So legal non-conforming is on the test, conditional is on the test, a variance is on the test. This is where you have a hardship, and you go to the Planning and Zoning Commission, you say, I have a hardship, I need a variance to this zoning. So it's an exemption to the zoning law. You have to prove that hardship. You're not entitled to it, you must prove the hardship. So an example would be that setbacks from the edge of the lot have to be 75 feet setbacks. And you go to the commission, you say, I need a variance. Because if it's 75 feet, I'm not going to have enough room in my backyard to put in my septic system. But if it can only be 50 feet, then I'll be able to put in my septic system. Can I get a variance? And they could grant you a variance from those setbacks so that you could put in, your septic system. Sometimes we have things that are zoned multiple times. So we have overlay districts. So it may be residential, but on top of that, we also have floodplain maps. So something is overlaid over the top. It could be residential, but then also historic, meaning that you have to keep things matching that historical era for that district. Or you can have aesthetic zoning. You have to paint things a certain color to maintain the aesthetics. You have to maintain a certain number of trees to maintain the aesthetics. So those can be things that are overlaid on top of just normal residential or something like that. And then we have spot zoning. And spot zoning most of the time is illegal because many times it's taken as money under the table to get somebody's, special needs met. But if it's in the public interest, then it is legal. It is legal. So when a particular property or group of properties is rezoned to permit a use different from all the neighboring properties, that's called spot zoning. That's a little bit different than your conditional use permit. Okay? And whether it's legal or illegal is going to depend upon, is it in the public interest? So the way that they determine this in North Carolina is the size of the rezoned area. Rezoning a single lot is a little bit more questionable than rezoning several lots. Okay? The degree of compatibility of the different zoning with the government's adopted plans for the areas. So how does this zoning fit into the master plan? All right. The impact of the rezoning on the landowners and the difference between the existing zoning and the new zoning. And so that's kind of how you determine spot zoning. Not a big deal, not a very complicated thing to know, mostly knowing that it is illegal in most cases, but it can be legal if it is in the public interest. So those are your zoning terminologies. Key thing, legal nonconforming, conditional, variance. They like to give you a tricky question on overlay districts, and they'll say something about so-and-so is going to repaint their house and they chose a color that was not an appropriate color for that era. Is that an example of spot zoning, aesthetic zoning, historic preservation zoning, or a legal nonconforming use? So the answer to that question would be historic, because even though it was colors, it said the colors of the era, not of some other aesthetic thing, but of the era. So that makes it historic. Okay. So your thing, what do you have to do as a broker? Mandatory disclosures. Pending, potential, and confirmed zoning changes are material facts and must be disclosed to all parties. So they have to be disclosed to your clients, they have to be disclosed to the customers, they have to be disclosed to all parties. The other thing that has to be disclosed, and we'll talk about this more, is streets. The status of a street as being public or private, and who's going to pay for maintenance is a material fact and must be disclosed to all parties. So street status, is it public, is it private, who's paying? Those are material facts. Those are test questions. Those are on the state. So subdivision regulations. You're building a subdivision. So if you're building a subdivision, that's typically that the division of land is into 2 or more lots. You're kind of creating your own subdivision. If you've got one piece of land, you're dividing it into 2 lots, maybe you're creating your own. But that's typically when a subdivision is going to have some type of regulations followed. So cities and counties are responsible for implementing subdivisions regulations. And here's the way that it works. There's a preliminary plat that is created, and it is filed and it is approved before you can take deposits, or you can put a lot under contract, or you can do any of that. Okay, take reservations. None of that can happen until the preliminary plot has been approved. Now, once it's been approved, you can take reservations, you can get your deposits, you can go under contract, but you cannot close until the final plat has been approved and recorded. You cannot close. If you do, that will send you up in real estate jail. Okay, that's a violation. And the reason that you can't do it is because something could change between the preliminary plat and the final plat, and the person may not be paying for what they thought they were. All right, so you cannot do that until final plat is recorded. You must comply with the street disclosure laws. Public versus private is a material fact. So who takes care of snow removal? Are all the homeowners going to have to be paying homeowners dues to get that in? What about when the streets need to be repaid? Who's doing that? Homeowners going to have to do that? Or is the government going to take care of that? And okay, the DOT doing that. And then protective covenants are enforceable in a subdivision. So you've got your restrictive covenants, also known as protective covenants, and they're going to be enforceable in that subdivision. Okay, so let's take a quick 10-minute break now. And then when we come back, I'm going to give you an example of public versus private management of streets. And then we will take a look at building codes. Okay, so let's take a quick break here.
Can you do me a favor and just go back one PowerPoint slide, please?
Yes.
Thank you.
Feel free to take pictures of these, but also know these are on Learn Test Pass, so you can print them out for yourself. All right, taking our break. is. Okay, resuming the recording. Here's an example of why private versus public street management is so important. So in a neighborhood where I used to live, the streets were privately maintained. So they're privately maintained. So with them being privately maintained, then it was time for the streets to be, they were getting in bad repair. And so it was going to cost $500,000 to repave all of the streets. And people were kind of freaking out about that. Okay, they were kind of freaking out about that. And so the board had to figure out, how are we going to do this? So we figured out that they didn't have to be repaved that year. We had a little bit of time. And in the bylaws of the HOA and the board, dues could be raised a certain percentage every single year without homeowner approval. So we said, let's just raise the dues, the maximum amount we can, which was like 3% or 1% or something. It was not a lot of money, every single year. And we'll take all that extra money and we'll start putting it in our reserve account. So we did that for like 5 years. So the money was in the reserve account for 5 years and building up, and every year the dues were increasing, we were building that up. Came time where we had to have it done. We got the quotes, we went through the whole process, we figured out the best thing to do. We got a loan from BB&T, which at that time had homeowners association loans. I don't think BB&T exists anymore, right? Then they merged with somebody or something. But anyway, at the time they were the ones we got the loan with, and did all the work, started paying off the loan, kept increasing those dues, were able to actually pay the loan off. I think it was like a 7-year loan, or maybe it was a 5-year loan, paid it off in 2.5 years. Okay. Homeowners never had any assessment. Their dues went up from $80 a month at the beginning of the stuff to like $125 a month at the maximum amount. Maybe it was just under $125. And that was like over a 5-year period. They increased that amount. So it was a very gradual increase. Once everything was paid off and there were good monies in the reserves, now the dues are being decreased. And so they didn't have to even stay increased for a long time. But that was a very neat way to have this happen. But what could have happened is they could have taken $500,000, divided it by 106, and had everybody immediately cough up the amount of money that it was going to take to repave the streets. And there was one person in the neighborhood who wanted that to be put to a vote. And I thought that person was crazy. So that did not happen. But you can see the difference there. So let's say if you had $500,000 and you divide it by 106, every single person would have had to cough up immediately $4,716.98, right? Well, that could be significant. But by gradually increasing it over time and using the reserves and investing the money, that was able to happen without that. But you never know which way it's going to go. So public versus private is always a critical material fact that you need to make sure you disclose. Okay. All right. So just kind of wanted to tell you about that. Now, the next thing we have to talk about is building codes. So building codes are your statewide codes, and they're for minimum construction standards. And they can be different based on different states, or, you know, because think about it. Building codes in Florida might be different than building codes in Wyoming, right? Because there's statewide codes for minimum construction standards. And safety is the primary purpose of these codes. So anytime work is done in your home, you need to get a building permit. And then inspections need to occur, and you need to have a certificate of occupancy to prove that the building that was done was up to code and is not going to provide some type of safety issue. If there is unpermitted space, that is a material fact. So let's say somebody decided, oh, I think I told you guys about this little house that we had that we bought in foreclosure, the very first one we ever invested in. And I finally wanted to get rid of it because, I mean, nothing that had been done in that was permitted. The guy tried to build it himself and nothing square, nothing plumb. It was like, oh my gosh, this is just like a hazard. I do not want this house. Okay. So that unpermitted space is a material fact. Licensed contractor didn't do it. Permits were not pulled. Okay. So if something had been added on, not only is that a material fact, but it may not be included in the heated living area because no certificate of occupancy was ever granted. So that is extremely important. And that is one of the key things you will deal with when you become brokers and you're looking at listing houses for people or you're helping a buyer. Okay? You've got to know about that heated square footage. You've got to ask if things were permitted. You need to see certificates of occupancy. Okay? Had an issue with the house just recently where there was a screened-in porch that was added. And it was permitted. There was a building permit, there was certificate of occupancy and everything. Came to do a septic inspection, come to find out, the septic tank is right in the middle of the two poles supporting the screened-in porch. And so both of these poles are closer than 5 feet to the septic tank, which is a violation. I mean, septic people were not going to pass a septic inspection. But because everything was permitted and there was a certificate of occupancy and it had been inspected, what was determined is that a variance had been granted. So everything was up and exactly where it needed to be. But in order for that to be approved, we had to have the permit, certificate of occupancy. We had to know that the septic permit had been pulled with all of that. All right. And then a variance had been granted. It really ticked off the septic tank people who were going to have to pump it because it made it kind of a pain for them to do it, but everything was above board. Now, if instead of a permit have been pulled and certificate of occupancy granted for this addition, they could have been in real trouble. Could have had to move the septic tank, could have had to take down the screened-in porch, right? That could have been a really big issue for the buy and sell of that house. So that's why building codes are important, permits are important, certificates of occupancy are important, and unpermitted space is a material fact. You don't want to get into that kind of thing. You never can tell. Somebody's wiring stuff, they don't know what they're doing, they might burn the house down when you're asleep in it in the middle of the night. So you really don't want to mess with that kind of stuff. All right, so let's kind of talk about building codes versus zoning ordinances, just so you keep this straight, okay? Building codes are construction standards and they're designed for safety, okay? And they're statewide. Zoning regulations are local laws that regulate how the land is used. So make sure that you don't get the two confused. So if you're seeing this on a page and there's a red star beside it, that means that they're probably going to be asking you a question that makes sure that you understand the difference between building codes and zoning regulations, and building codes being statewide, construction standards for safety, and zoning regulations being local laws that are regulating land use. On-site septic systems. Only 3 things you need to know. Hot's on the left, cold's on the right, and yep, it flows downhill. So what you have with this is you have a PERC test, also known as a soil suitability test, that will tell you the number of bedrooms you can have in a home. The reason it's done based on bedrooms instead of bathrooms is that you could have 1 bathroom, right? That's the way it was back in the day, 5 bedrooms. Everybody's sharing a bath, so they just had to wait their turn. But 5 bedrooms, if you think about 2 people per bedroom, which is the way the standard was determined, that would be 10 people. So 10 people peeing and pooping all the time is a high demand on a septic system. So the number of toilets is not what's important. It's the number of people that are flushing those toilets that is important. And so if a septic tank only perks for 2 bedrooms, even if people are using 4 rooms in the house as bedrooms, you can only advertise it as a 2-bedroom house. And if you advertise it otherwise, you are doing willful misrepresentation, which can get you in trouble with the Real Estate Commission. AKA, what we like to say is it'll send you to real estate jail. Now, that's not a real place. They don't actually put you in jail. It just means that you've gotten in trouble with the Real Estate Commission, and they can censure, reprimand, suspend your license, or even revoke it, depending upon the severity of what you have done. So your broker, you must disclose all septic material facts to all purchasers. And especially make sure you're not inaccurately advertising occupancy levels. You cannot say it's a 3-bedroom if it only perks for a 2-bedroom. Okay, any questions about septics? All right, so now we've got flood hazards. We'll talk about this more when we talk about insurance. But flood hazards areas, okay, are designated by FEMA. And FEMA is the group who administers the National Flood Insurance Program. Where do you get this insurance? Well, you still get it from your regular insurance carrier, but it's not part of your normal homeowner's policy. It is an additional insurance policy. And like I say, we'll talk about that more when we talk about insurance. But your flood hazard regulations are subject to federal regulations, right, for improvement or construction in areas. If it's a flood zone area, then there are additional regulations. Flood insurance is separate, like I said, from regular homeowner insurance. And you really need to look at flood maps and have a survey to find out if you are in a flood zone. And that would be an overlay district. That would overlay on top of your residential. So if you are in a flood zone, a designated flood zone, floodplain, and your lender is probably going to require you to have flood insurance. Right? If you don't have a loan, you might not be required to have flood insurance, but that might be very unwise, because then if there was a flood and you did not have flood insurance and you were in a flood zone, you lose everything. You've got no recourse. You've got no way to get your money back. Highway access, public road access has value and usability impact. So you must disclose material facts about road access. So this can be a positive thing about road access. You know, it's like, feel like you're living in the country, but be on I-40 in 2 minutes. Okay? So you've got major road access. Okay? But it could also be the other way, okay? Where road access is very difficult. This is not a state maintained road. When it snows, okay, the artery that gets you from your street to where you can get to a road that's maintained by the state is not, you know, it's not going to be plowed. You might not be able to get out. So different things that you may have to disclose about that, right? Just to make sure that people are understanding kind of what's going on with regard to access, okay? Now, also with regard to that, if there's planned construction of a highway, then you need to know about that. I had a client who was looking at a house and they're like, oh my gosh, this is the perfect house. It's everything that we want. But I think it might be somewhere close to that new loop they're getting ready to put in. Come to find out, that's exactly why they were selling it, because the long-term plan was going to have the new like bypass around the northern end of Forsyth County, or wherever that was going to come, so that walking out your front door, that's all you were going to see. It was going to be like, you know, 100 yards away or 50 yards away, and there it was. So that was really impacting the value. That was definitely a material fact. So you need to make sure you disclose that. Privately imposed land use controls. So these are things that are imposed and enforced by individual property owners as deed restrictions or as protective covenants for a subdivision. And it's going to apply only to the subdivision that's identified. not any of the ones that surround it. It is pertinent, right? It's binding on, it runs with the land. It's binding on all subsequent owners. So it's not just you because you were there when it got started, right? But it's binding on everyone. Enforcement is generally transferred to a homeowners association from the developer who initially creates it. And it can be for anything that is not illegal. It can be for anything. It can be that you cannot park a commercial vehicle in your driveway or on the street. It can be that you cannot have a chain link fence. It can be that you cannot have any fence. You cannot have a satellite dish. It cannot be an Airbnb. You can only paint your house gray. You can only paint your house pink. I mean, anything it can be. And it's privately imposed. As long as it's not illegal, you can do it for anything. And if you violate it, you will have to remove it. Or if you refuse to remove it, they can come and remove it for you and make you pay for its removal. If you built something, for example, that was not compliant with those restrictions. Any questions about that? I've seen one that said no toilets in the front yard. Oh, that's great. Yes, yes. No toilets in the front yard. For some reason, people like to use old toilets as planters. I don't know what they think is attractive about that, but I actually did do that one time. It was really kind of cool. We did it as a joke because it was close to the bulky item pickup day, and we had replaced the toilets in our house, and we were putting the old toilets out for bulky item pickup. So we stuck them in the front yard, and we stuck geranium pots, you know, in it just as a joke to see if anybody would say anything. And people did say a lot of stuff, but they figured out and they knew it was a joke. So yes, I have seen that for no toilets in the front yard. It's hilarious. Anybody else seen anything crazy like that or interesting or funny?
I've seen a bathtub used as a planter before off of Robin Hood Road.
Oh yeah, yeah. Yeah, it's amazing what people will use, you know, as planters. And so you have to like tell people, yes, you can, or no, you can't, or you never can tell what might end up, what some people's taste is. Like, I've never understood how people put their upholstered furniture on the front porch. Not like furniture, but it's like, you know, micro suede furniture on the front porch. As soon as it gets wet, ew. And so that's something I've seen in restrictive covenants before.
I know a woman that got divorced and put her husband's boat that she got in the settlement out in the front yard with flowers in it.
Well, there you go. Yes, yes. And people are saying they've seen no furniture on the front porch, like no sofa on the front porch. Yeah, it has to be furniture that looks like it's supposed to be outside, not looks like it's supposed to be in the man cave. Yeah, yeah. So crazy things can happen here. So your restrictive covenants. Go ahead.
On these privately imposed land use controls, what if you live in a neighborhood that's been established for a long time and there's no homeowners association? Then can you really even have these?
No, not every place has them.
Okay.
Some places do not have them. And in fact, sometimes that's a selling factor. No HOA, no restrictive covenants.
Okay, thank you.
Yep, yep, you can have them, yeah, or not have them. All right, so what are your responsibilities as a broker? You want to review the land use controls before listing a property or writing an offer on a property. So before listing, you're working with the seller. Writing an offer, you're working with the buyer. You want to verify that what the buyer's planning to do will be allowed. Now, here's a great example of that. In my neighborhood in Boone, no short-term rentals are allowed. No long-term rentals are allowed. Well, any rentals that are allowed have to be approved by the HOA, okay? So it could be a very long-term rental. And here's an example of a long-term rental that they would allow. Right, let's say that a couple was buying the house. They were buying the house so that their retired parents could live there. The retired parents were going to be paying them rent. That is technically a rental. When the parents die, okay, then the couple will have ownership of the property and they'll use it as their second home. So that's an example of a rental that the HOA would approve, because that makes sense. But an example of one that they would not approve is we're renting it for this year to 4 college students. That would not be approved. So they have complete control over any long-term rentals, and they do not allow at all any short-term rentals. So you could not make your house an Airbnb. You could not make your house a vacation rental when you were not there. So that is a restrictive covenant, and you need to know that if you have someone wanting to buy in it. So I had several people, when I had this one house listed, there would be other realtors, brokers would be calling me and saying, hey, are short-term rentals allowed? No, in fact, no rentals are allowed. Because that's sometimes important. People want to have it, but they also want to use it as an investment property. Another thing.
I have a question.
Go for it.
I'm sorry, I have a question. So if you misinform somebody of these restrictions and they end up buying a house, say the restrictions say no farm animals, well, you have chicken coops that you're planning on moving over here to your new property and you've already bought this house, is the real estate agent therefore in trouble at that point with the association?
Yes, yes. So the agent would definitely be in trouble at that point. Now, which agent would be in trouble? So if there was, it depends. So let's say that your buyer said to you, I'm planning to bring my chickens with me. Is that going to be okay? And you called the listing agent and said, they're going to bring their chickens with them. Is that going to be okay? And the listing agent says, absolutely. There is nothing in the restrictive covenants that prohibits chickens. Now, if that agent knew that chickens were prohibited and they told you that they were not prohibited, then they're going to get in major trouble because they willfully misrepresented. They told you a lie. They knew they were telling you a lie. So a complaint could be filed and they would get in major trouble. Let's say that you called them up and you said, hey, my client wants to bring chickens. Are chickens allowed? And they said, sure, as far as I know. And they never checked. They're still guilty, but then it's probably negligent. They didn't know for sure and lied intentionally, but they should have gone and looked and not just said, sure, they're okay, because I know they're okay in the neighborhood next to across the street. So that would be negligent. So the seller's, the listing agent has more of the burden, but you are the buyer's agent. The restrictive covenants are right there for you to download and take a look at, right? Your response to your client should not be, sure, chickens are allowed. If they ask you and you've checked with the other agent, you still need to say, I checked with the other agent. They said chickens were allowed, but here's a copy of the restrictive covenants. Why don't you read them and make sure for yourself? And if you have any questions, consult your attorney. If you have any specific questions, I can get the president of the HOA's phone number for you and you can talk to them directly. So that would be the best way to keep yourself out of hot water. Make sense?
I got you. Yeah.
Cool. All right. So restrictive covenants versus local zoning. This is just like the rules for the coronavirus, right? If in conflict with local zoning, the more restrictive covenants prevail, okay? So whichever is more restrictive is going to prevail. So if you've got zoning and you've got restrictive covenants, whichever one is the most restrictive is going to prevail, right? So it's kind of like with this coronavirus, right? The state said XYZ, Forsyth County said ABC. Whichever one was more restrictive was the one you had to follow. You couldn't say, oh, I'm following the state. I'm not following the local ones. I'm going to follow the state, all right, because I like those better. Right? Whichever one was the most restrictive is the one that's going to prevail. Right? So the only time a restrictive covenant would not prevail is when it was illegal. When it was illegal. meaning that the law had changed to make it illegal. And I think we talked about that earlier today. All right, so here we go with question. The government regulates all of the following except. Remember, this is our true false stuff. So 3 of them are going to be the same thing. One's going to be different.
D.
So we're hearing D. Yes. Who controls restrictive
D.
covenants?
HOA.
The HOA. The HOA. Yep. HOA, POA, deed restrictions. But subdivisions, building codes, and subdivision regulations are all done by the government. Those are all police power. Okay. So here we go. All right. Key terms from here. Strict disclosure laws. Police power. Variance. Variance is on the test. Non-conforming use. That's on the test. Legal non-conforming use, right? It's grandfathered in. Spot zoning, usually illegal unless it benefits the public. Interstate Land and Full Disclosure Act. Okay, let's talk about that for just a minute. So believe it or not, if you've ever heard somebody say, hey, if you believe that, I got some swampland in Florida I'd like to sell you, right? That's exactly what happened. So years ago, there were some shysters in Florida that actually sent letters to people in North Carolina. This was before the internet, and made phone calls to people in North Carolina. And what they did was they said, hey, we want, there's some great land that you can buy, and you can buy this in Florida, and it's going to be an awesome investment. And so the people bought it, and then they went to see it at some point, and they found out it was out in the middle of the swamp. There was absolutely nothing that they could do with that land. They had been screwed, right? So that brought about the Federal Interstate Land Sales Full Disclosure Act. And so what it does is it regulates interstate sale. So selling Florida land in North Carolina of unimproved lots. Unimproved means that, if we remember from, I think it was yesterday, unimproved doesn't yet have water, sewer, electricity, so it's an unimproved lot. In subdivisions are 25 or more lots of less than 20 acres each. Okay, so that means that you've got to disclose a bunch of stuff. It does not apply to subdivisions sold solely to developers, but sold to individuals. And that is all because of people kind of getting screwed. Okay, they were getting screwed with that. Okay, so just kind of keep that in mind. That's not a big thing, just that Interstate Full Disclosure Act, that came about in 1968. Okay, and so it's just to protect you from fraud. Protect you from fraud. And so you just want to make sure that they must file a statement of record and register the details of the land with HUD, right, to make sure that it's not something that is bad for the consumer, right? And so just keep that in mind. That's a very minor topic. It's like 2 sentences in there, right? But anyway, if you're a broker involved in selling lots across state lines, then you need to make sure that you follow all the rules and regulations, and it's best to consult an attorney because you don't want to be in violation of the Interstate Land Sales Full Disclosure Act. It's just basically saying you got to disclose everything about this land when you're selling it between states, interstate, right? So that people do not get screwed. Now, when we were talking about septic tanks, I'm going to go back to septic tanks for just a minute. Okay, here we go. So there's something that I wanted to tell you about with regard to septic tanks. So you typically need to know if it's septic or if it's sewer. If it's septic, you're really not supposed to even have a garbage disposal. There's certain special ones that work with septic systems, but that might even be restricted. So you're not really supposed to even have a garbage disposal if you have a septic system. But sewer garbage disposal is just fine. On the RPODs, which is the Residential Property Disclosure, which we'll be taking a look at probably next weekend because we hit all the hefty chapters next weekend. We're taking a look at that. It's going to talk about what kind of sewage disposal do you have. And one of the kinds is something called straight piping. Has anybody ever heard of straight piping? What is straight piping? Anybody know? What's straight piping?
That's when you
Well,
don't have a treatment system to treat your wastewater.
Yeah, it's where wastewater is just discharged directly into the yard. Your waste just goes directly into the yard, or it goes into a nearby creek, or it goes into a nearby stream. Okay, that's not legal. You cannot have straight piping. In most instances, straight piping is illegal. Okay, you have to have proper sewage disposal. Okay, so straight piping is illegal. You can't take your washer dryer and have the water go out into the backyard. Okay? Now, that being said, that doesn't mean that there can't be certain recycling systems where you have the gray water going out to water your garden, that kind of thing that people do for environmental concerns. That's not straight piping. Okay, there is only one time that I can think of where straight piping is not only legal, but it's required. Okay, and it's not going to be sewage. Okay? I'm not going to tell you that it's sewage. It's not poop that's going out, right? There's one time when having a sink with the drain going straight to the ground is not only legal, but required. Does anybody know when that time is? I'll give you a hint. It's typically used on Sundays, but not during the coronavirus. That's hint one. Any guesses? Is anybody?
Church's baptisms?
Oh, hey, that's a good guess. Baptismal fonts for churches. That's a really good guess. And you are on the right track. It's not that, but you are definitely on the right track. Excellent guess. So here's hint number two. Anybody in here Roman Catholic, Episcopalian, or Greek Orthodox? So yes, it is at a church. Now we're getting communion. Yes, we are definitely getting there. So in the sacristy of Roman Catholic, Episcopalian, and Greek Orthodox churches, at least those, if not others, where you have communion every single week, okay, sometimes every single day, you have mass every single day, and you believe that, all right, the body and blood, okay, the wafers and the wine become the actual body and blood of Christ. You believe that, right? And then you're cleaning up after that service. You don't put Jesus into the sewer. You have a special sink, right, where when you are washing out the chalice and you're wiping off the place that the communion wafers have been on, okay, you put it down that sink and it goes straight into the ground, straight back into the ground, not into the sewer. So that is a little known factoid about when straight piping is not only legal, but required out of reverence.
Wow.
Yeah, isn't that cool?
Yes, that is
cool.
very cool.
Right. So I know that because I'm Episcopalian, and so that's what we do, and so I always like to throw that one in. Okay, so let's see. Yes.
Going back to that, I mean, does the church have to get any kind of special permission to do that, or they just do it?
Yeah. So when things are constructed, there are actually two sinks that are constructed in the sacristies. So they have a regular sink that goes like into the sewage stuff, and then they have the other sink, and things go straight into the ground. And so there's been a building permit, and there have been inspections and things that have occurred with that.
Oh, interesting. Thank you.
Yeah. That's one of like my cool things.
Is that regulated? Does that make sense? Like does people come out periodically and make sure you're not putting stuff down there you're not supposed to?
Yeah, I've never seen it be inspected, although I guess the health department could inspect something like that, at a church. I'll ask the priest at my church if that has ever been inspected. But I mean, it's used for such a reverent purpose, and only the Altar Guild ever does that, and they go through extensive training, so it's not likely that it's abused. That would like be a sin. But I'll ask. That's a good question. I've never thought about it being regulated or how they would even regulate it. But being a member of the Altar Guild and having to go through that training and learning all of that kind of stuff and seeing it in practice, you kind of understand the reverence that goes with it. So you wouldn't be likely to do that. I guess maybe the janitor could do something like that, but I don't know why they would. But that's a good question. I don't know. I have to check into that and see if it is, inspected at any point in time. Okay, so the next chapter is really short and really fun, and it's chapter 20, and it's environmental controls. So we're going to go ahead and we're going to look at environmental controls before we have our next break. And then, oh, I had it open. I guess I just closed it. I did. I just closed it accidentally. So these are environmental issues. So this is a really neat one. I really like this, and this is fun. This is easy. You got to know it. It's on the test, right? But it's good stuff. It's good stuff to know. It's easy stuff to know. It's fun stuff to know. And so we're going to go ahead and take a look at it now before we do our last break. All right, environmental issues. So this is 20. So we're kind of throwing it in because we've been talking about land use controls and things like that. And this is a short, easy chapter before we get to the heavy duty stuff. Okay. So what are the basic environmental hazards you should be aware of in order to protect the interest of your clients? First one of those is lead-based paint. So what about lead-based paint do we need to know in the Lead-Based Paint Hazard Reduction Act? What are the warning signs, characteristics, causes, and solutions of the most common environmental hazards found in real estate transactions? And these are things that you're going to be thinking about and looking at with every single transaction. There are going to be questions that can come up, okay? And so that's what we're going to be talking about here now, because this is something that's very relevant to every transaction that you do. So environmental issues. Everybody's concerned about environmental issues now, and they should be, right? Because, even if we want to think, unless the conspiracy theory that China intentionally released the coronavirus from the viral research lab that they had really close to that wet market in China, okay? An environmental issue of the cleanliness of that market and the way that the animals were all put together and all of that kind of stuff could be what's causing us to have all this pandemic stuff that's going on right now. So environmental issues are of paramount importance to people and becoming more and more so every single day. So you have to accurately disclose what you know about the property. And you have a liability for discovery and disclosure. So it is very, very important. Okay? So what are the most common hazardous substances? Asbestos, mesothelioma. How many people have seen that commercial on TV? Mesothelioma, right? That's asbestos. Lead-based paint, radon, urea formaldehyde, carbon monoxide. That's important. We'll see that in a lot. Electromagnetic fields. I have people that are like, nope, that house is too close to the big pipe, to the big electric pipe lines and poles. I don't want that. Groundwater contamination, underground storage tanks, and waste disposal sites. For example, the golf course Winding Creek in Thomasville was built on top of the old Thomasville landfill. All right, that's what they could do with it because people didn't want to go build their houses there. So those are your major hazardous substances. Now, there are a few of them that are on the test, and those are the ones that we're going to focus on most of the time here. Asbestos, number one. Asbestos was once used in installation, okay, due to the fact that it was heat and fire resistant. In fact, they used to put asbestos fibers in kids' flame retardant pajamas before they knew about the dangers. Now, what you need to know about is asbestos is that it is friable. That doesn't mean you need to go stick it in your air fryer, but it means when you are disrupting it, the fibers break into small little tiny pieces They get into your respiratory system and they cause disease. They cause mesothelioma, which is a form of lung cancer. So what do you do if you've got asbestos? You don't try to remove it, because as soon as you try to remove it, all of that friability, right, becomes relevant. And it's extremely dangerous to try to remove it. In fact, even if you're encapsulating it, which means you're just sealing it off, you still have people coming in to do that wearing hazmat suits. That's how dangerous it is. Used to be commonly used before we knew. Once we used, now that we know, we don't even use it at all anymore. And places that have it, sometimes the cost of encapsulation or removal is so great that the place just becomes unusable whatsoever. There's a hospital up in the Blowing Rock, no, it's Banner Out, Sugar Mountain, Valley Cruces, up in that area as you're going through there towards Newland, that that has no use whatsoever, because asbestos was used way back in the day, back in the 40s, okay? Asbestos was used, and the cost of encapsulation is so great, nobody's willing to buy that building and do something with it. Lead-based paint. Somebody already put in the chat box, 1978. You do need to know that date. Lead-based paint disclosure, okay, and the hazard addendum is required in all homes that were built before 1978. And they will ask you that year, and you must know that year. So lead-based paint was used as a pigment and a drying agent in oil-based paint. I mean, lead was. That's what it was. It was used, okay? And it was banned in residential property in 1978. And right about the time it was banned, there were all these commercials about being careful to make sure your kid wasn't licking the paint on the windowsill, because it could have lead in it, and that could lead to brain damage, nervous system damage, kidney damage, red blood cell damage. It was very bad. So now they got rid of lead in paint, and from what my painter friends tell me, paint just never been the same. It's not as good as it used to be. Right? But you still can't use it. It's illegal. You can't even find it in it. So anytime there is a home that was built before 1978, you have to have the lead-based paint hazard addendum, and it must be disclosed. Okay, it must be disclosed. So that's important. That's going to be on the test. That's going to be on the test. Okay, so anytime there's lead-based paint, you've got to let people know. Okay, and yeah, it's not just sales. It can be it's in leases, it's in commercial. Anytime there's lead-based paint, you've got to make sure that that is disclosed. Radon. There's a radon mitigation system in this. Radon is a colorless, odorless gas that is produced by the decay of radioactive substances in the ground. Okay? It's found in every state. It can be in one house and not in one right next to it. The safe limit is 4 picocuries, below 4 picocuries. Okay? Anything above 4 picocuries is undesirable, meaning it's probably going to give you cancer. Right? So when people are having their inspections done, you typically also have a radon inspection. And if radon is found to be in there, and from what my people tell me, my inspectors tell me, that if the radon level is between 2.5 and 3.9, then it is recommended that you mitigate. I mean, you put in a radon mitigation system. If it is above 4.0, it is required that you mitigate. They're not very expensive. It's less than $1,000. SWAT Radon is one of the people that does it. They're like $9.95. They'll come out, they'll put in a system that looks just like that. It's ventilating everything up. As long as it's working, you don't have to worry about radon. Any questions about radon? Radon is on the test, or asbestos is on the test. Lead-based paint is on the test. Carbon monoxide. Okay, again, colorless, odorless gas. You can get it from a gas stove, a gas fireplace, gas water heater, gas pack heat. All those types of things can produce carbon monoxide. It causes death because it inhibits the body's ability to transport oxygen. You get too much carbon monoxide, not enough oxygen, you're going to die. So you need to have a monitoring system, carbon monoxide detectors. You need to have good ventilation. All those things are required. And if you have rental property, you are required to have carbon monoxide detectors if you have any type of fossil fuels in place. Okay? And this is why you see carbon monoxide is so dangerous. This is why you see every time there's a winter storm, which has been a long time since we've had one, but there's a winter storm and they think the power's going to go out. They're telling people, don't bring your gas grill inside and turn it on to heat up the house and cook your food, because you're going to be releasing all kinds of carbon monoxide and everybody's just going to die. Okay? So you have to be very careful with carbon monoxide. Underground storage tanks. All right, so my parents, in the house I grew up in, they had oil heat until natural gas came in. They had an underground oil storage tank. And so there are millions of these in the United States, and they've just been abandoned. And if they have not been properly sealed or removed, right, or cleaned out and then sealed, leaks can contaminate the soil and the groundwater. You can be getting oil into the soil, oil into the groundwater. This is not a good thing. And once this has happened, removal, cleanup, those kinds of things can be extremely expensive, especially in old gas stations where they have large underground storage tanks. It can be very expensive. And there are strict state and federal requirements for detention and cleanup. And if you are the owner of a home, you are responsible if there is an underground storage tank. Even if you didn't know it and you didn't put it in, you're responsible for its cleanup. So this is a material fact, and you want to be sure that your clients know if that is an issue. I have a little story about that. I have one of the people in my firm in Boone, she came to me one day and she said, I don't know what to do. She said, I got a client interested in this piece of property. She said, I was looking at the MLS listing, and I went to check previous MLS listings to see the history. The previous MLS listing said there was an underground storage tank, an underground oil storage tank. This listing doesn't say it, but there's a pipe in the yard. And I said, okay, well, I think you probably ought to have it inspected and checked out. She said, yeah, well, I asked the listing agent about it, and the listing agent said, I don't know anything about a storage tank. And so I said, yeah, but it was on the previous listing. She said, I don't know anything about a storage tank. She said, what am I supposed to do? It sounds like she's trying to hide a material fact, and that's not good. And this is like the leading agent in our firm, and what am I supposed to do? And I said, did you talk to the broker in charge? And she said, yeah. He said to go to her about it. Did you go to her about it? Yeah. And I said, okay, well then if the buyer's have an inspection, it'll be turned up, or have them go find another property. So a week or two goes by, she comes back to me and she says, it's been updated in the MLS now to say that there might be an underground storage tank. It appears that there's a pipe in the yard. So that's stuff you don't want to mess with. Question?
That's one of the most expensive things, especially commercial. We run into it buying a piece of property for the dealership, and it cost over 50 grand to get the tank out, the soil around it that it leaked into and everything else, and then to redo the lot. So it's huge. Yeah, it is huge. And there used to be a fund for it, and those funds are now gone. So it's the responsibility of the owner to take care of it. Yeah, major, major issue. So what's your liability? So like we were saying before, the seller carries the most liability because they're the one who's supposed to be disclosing all these material facts on the MLS. So they have the most liability. So brokers on both sides, they might be liable for improper disclosure. You always want to cover your assets, right? CYA. This could also infect appraisers, insurers, inspectors, right? Now, you're not expected to discover hazards, but you're expected to disclose known hazards, known contaminants. You're not going to go out there and do the test for the radon, right? There's people that do that. But if there is something that's present, you must disclose it, okay? If it's something that you should reasonably have known, okay?
then you have to disclose it. All righty. You do need to know asbestos. You need to know friable. You need to know encapsulation. Carbon monoxide, what are the things for that? Radon mitigation. You also need to know 4 picocuries. You need to know it causes lung cancer. You need to know asbestos causes mesothelioma, which is a form of lung cancer. Lead-based paint, 1978. Lead-based paint addendum. You need to know about that. Okay, so those are the key things. All right, let's take about a 10-minute break and come back and do a little bit of review for the day, a little more math, a little bit of breakout group. Here, lead-based paint, this is the one that has to go with your offer to purchase and contract. It's going to list the name of the property, the seller, and the buyer, the lead warning statement, okay? And then the seller has to disclose, and they have to initial, okay? Presence of lead-based paint or lead-based paint hazards, check 1 below. Lead-based paint or hazards are present in the house, and explain where they are, or they have no knowledge of them, meaning that maybe they've repainted so many times they don't think there's any lead that's an issue. And then records and reports available to the seller. The seller has provided the buyer with all available records and reports pertaining to lead-based paint, okay, or hazards, and list the documents, or the seller has no reports or records. Then the buyer initials that they've gotten this information, that they've gotten a pamphlet that you have to provide for them. And again, you can download this off the commission website, or it's hyperlinked. Protect your family from lead. And then they have to check, have they gotten an opportunity during the due diligence period to conduct a risk assessment, or they waived the opportunity to conduct a risk assessment. And then the agent has to acknowledge that they have informed the seller of their obligation and are aware of their responsibility to ensure compliance. So that's the lead-based paint addendum that goes in with all offers to purchase homes that were built before 1978. So I did want you to have a chance to see that. As you get through all of these things, once you have finished all of the first, units, and you've kind of reviewed these things, and it's getting to be about Friday of next week or Thursday, and you've had some time with this, you might be ready to take a little practice exam. And so practice exam, we have an exam mode for it, and this is where you answer it. Okay, so you answer the question and you don't know if you got it right immediately. You wait until the end and you see how well you did on all 45 of them. Then there's a review mode. So after you've done it in testing mode, you can go through it in review mode, and this tells you the right answers as you go through. So that's a little bit different way to look at it. Then I have an overall quiz in here, an additional one. And again, I would space these out, right? So maybe you don't do 1 through 6 and 20, the paper pencil one, until 2 or 3 weeks from now, a couple of weeks from now, when you need a review on it. And then the answers are there for you. The other thing I wanted to make you aware of before next week is this major math review. This is like an 80-page document. It is a major math review of everything that you need to know for pre and post with regard to math. Right? And so it goes over calculations and information. It is a reference guide for you. Extra practice on everything that we do. Details on every single thing. So this is a huge, maybe something that you want to print out. Maybe you print out the syllabus and you print out this. It'll be about a couple hundred pages, but it might be well worth it. So you kind of, everything is here. And then after you get through all of these things, then you have the answers at the end, okay? So this is here. Don't expect you to have looked at this by next week and done everything, because we haven't done the majority of this yet. We've only looked at a little bit of, area and volume calculations, and we've looked at a little bit about assessed value, right? So we've looked at a couple of things here, and there may be some excise tax in here a little bit later. We haven't looked at nearly all of this stuff yet. So I just want you to know that it's there. And I give it to you at the beginning so that you've got it to use throughout the class. Okay? So just kind of wanted to give you a little bit of a tour of those first 6 items here, plus 20, and see if anybody had any questions before we do a little exercise to exercise our math capabilities here in our small groups.
Hey, Jane, can you hear me?
Yes.
Hey, I do have a question. So as we've been going over this, especially the asbestos and the lead paint, I'm thinking to myself as an agent and someone wants me to list their home. It's an older home. I'll walk in and I look up at the ceiling, and those old ceilings that are like the squares.
Yes.
I'm not sure, but I've been told that they may be asbestos. So and I don't know that for a fact, but I'm thinking as an agent, and I ask the seller about if they know that there's asbestos. They don't know the answer to that. I guess I'm thinking, where do we, how can we list it if they don't know and we don't know, you know
Well,
what I'm saying?
That's kind of where caveat emptor comes in. So North Carolina is a caveat emptor state. Let the buyer beware. So the buyer agent should be recommending to them that they get an inspection. And the inspection would identify that. Now, if you're seller or you are concerned, ideally, a seller gets an inspection and an appraisal before they even list it. So the appraisal helps you know what to list it for. The inspection finds out if there's anything wrong and they can go ahead and remedy it. But lots of sellers don't do that, right? Lots of them do not do that. So that's just always something that you can recommend if there's ever any questions. So I have a client that has a farm that they're thinking about listing. There's no way I could figure out what they should ask for their farm doing a CMA, because there aren't a lot of farms that sell every 6 months, right, in Yadkinville. So I recommended to them that they get an appraisal. And so now they know from a certified appraiser what they should ask for the farm when they decide to sell it. And I also had them get an inspection so they could see what needed to be fixed before they listed it, because it's a turn of the century, updated, remodeled farmhouse with 20 acres of land and ponds and outbuildings, and it's really quite unique. But it's so unique that a traditional CMA really wouldn't tell you anything. Does that help?
Yes, it does. Thank you.
Cool. Other questions?
Question. I'm getting ready to sell a house myself before I get my realtor's license. That way I won't be I won't be as much responsible. I guess the easier way to put it, for selling by myself. The question is about getting an inspection. Is it better to get an inspection done beforehand while selling it yourself? That way, a person comes in there that this has already been done, might increase the value of it, or at least increase the value in their eyes.
Yeah, so there are 2 different schools of thoughts on that. So one is, yes, you go ahead and get the inspection. You have the things addressed. You include the inspection, the fact that you've had the inspection, the results of the inspection, and what you have done. And so that might satisfy someone so that they don't get an additional inspection. Right. So that's a great, that's a great selling point. Another great selling point is to provide a home warranty. That's a $350 to $500 expense on you, provides a home warranty, covers all the major things. So I've used that as a negotiating tool with due diligence requests before. Somebody's requested this and this and this. And I said, well, what if we just give you a home warranty? Oh, yeah, that'd be great. Yeah, we'll take care of everything else. We can get a home warranty. So you just never know what people are going to go for or not.
Right. I just associate it back to where I sold cars and trying to build value into something.
Sure.
To alleviate some of the questions that the customer might have, get them more interested in it.
So it's always advisable. A lot of people won't do it. They'll be like, yeah, well, maybe they won't get an inspection. Maybe the inspector won't find this. Maybe, I'll just deal with that when it comes up, but it may not come up. Right. So those are the 2 schools of thought. So the recommended thing always is it's best if you get the inspection up front.
Right. CYA. Gotcha.
CYA, cover your assets. You got it.
Thank you.
Other questions?
What's the length on the home warranties normally?
They're typically a year, and then you can, the homeowner can renew it.
Thank you.
Mm-hmm. Are you given any formulas on the test? Absolutely not. Nope, you're given nothing. Now, that didn't mean that as soon as you walk in, you can't write down any formulas you think you might forget, or that kind of thing, but there are no formulas given on the test. Other questions? You really don't, by the time you're through the end of it, you pretty much know the stuff that you're going to need to know. You won't be forgetting formulas. Okay, so what I want us to do now is we're going to go into our small groups, and I want everybody to take the math skills pretest. And you can do this individually, or you can do it in your groups, or you can kind of do, them as we go. Just kind of want to see where everybody is with regard to some basic math skills. We've already touched on math a little bit, but I kind of want us to end the day on math. And so we'll take a few minutes to let you go through some of these questions. They're not hard. They're pretty quick and easy. There's just 10 of them. And then we will get back together and review the answers. So let me, alrighty, so how did we do on the test? Let's just start out by saying, any issues? On number 1, 2, or 3? Anybody? It's pretty straightforward.
No.
Yeah, very good. Okay. Number 4, you do need to know the formula of the area for a triangle is 1/2 the base times the height. Sometimes that's not on the test, sometimes it is. Just depends on which version of the test you get. And we'll see some examples of how to apply that. So number 4 might have been a little bit tricky one. 5. We got that one, right? We did some of those today. Anybody have trouble with 5?
Well, I rounded mine's up to be 1.38.
Okay, that's fine. That's fine.
Okay.
Yeah. Number 6. Any issues with number 6?
No.
Okay, good. Number 6. Number 7 is a little bit tricky, but this is leading us into some concepts that we'll be talking about going down the road. If you sell your home and walk away with $100,000 in your pocket at closing and paid the agent 6%, what was the sales price of the home? So we're going to say 100,000 is 6. Okay, so we got, what you have to be able to do is subtract the 6% from the 100,000 and divide by the number you get. Okay, so 100,000 is 6%. We walked away. Well, it probably should say is 6% less of what number, right? 6% less of what number. So it's 6% less. Another way to think about that is, okay, if that's 6% less, then 100,000 is 94% of a number. And so you divide by 0.94 to get 106.382.98. So then if you took 106.382.98 and multiplied that times 6% and subtracted it from 106.382.98, you would get 100,000. So that's kind of where the 100,000 is 6% of what? Okay, so it's really the way that you do this. And you will do several problems like this. You'll become an expert at this. And all you need to know is that you've got to take the 6% away from your total of 100% and divide by the number that's left. Okay?
I have a question.
Yes.
That one was confusing for me. So basically all you did was just take 6% out of 100,000 and then you convert it into a decimal to get your...
Okay.
No, not quite. So it's a little bit different than that. So let me share my other screen and explain it a little bit different. Sometimes trying to get the words to make sense in writing when you can't draw it out, it's a little bit trickier. So what we're saying is, the person actually, so the seller at the closing, they got a check for $100,000. Okay. And they had to pay 6% commission. So if they walked away with $100,000, that meant that they got $100,000 after they paid the 6% commission.
Oh.
Okay. So they're walking away with $100,000. So they got that after paying the 6% commission. So if the $100,000 is 6% less than the sales price, right? Then it's really 0.94 of the sales price, or that is 94% of the sales price. So if that number is 94% of the sales price, then what is the total sales price? Okay, so that's going to be 100,000 divided by 0.94 or divided by 94% to get the answer. Now, let's say that you weren't sure which way to do it. You weren't sure if you were supposed to do 100,000 divided by 0.94, if you were supposed to do 100,000 times 0.94. How could you double check yourself? All right, so 100,000 divided by 94% or 0.94 is the 106,382.98. Okay, if we round it. So let's say you weren't sure and you accidentally did 100,000 times 94%. Well, then you get $94,000, right? And so then you have to, this is where you have to go, okay, if they walked away with $100,000 in their pocket, it would have been impossible for the sales price to be less than that. So, oops, I must have done my math the wrong way. I don't multiply, I divide. And then once you get this number, you can actually go back and you can check it. Okay, and so two ways to check it is to go the other way. Okay, if this was my sales price and I had to pay 6% commission, how much am I going to put in my pocket? Well, I'm going to put 94% in my pocket, right? And so when I do that, then I get $100,000. So that's one way to check it. Okay. The other way to check it is 106,382 times 6%. Subtract it, and you'll still get $100,000, or within like a cent or something like that. Okay. Does that make more sense on that one?
Yeah, it does. Thank you. I didn't know what to do with the 94,000 I kept getting.
Yeah, exactly. What to do with that 94? Yeah, what's going on with this? So so the next thing that we will do a lot of these problems, and it's called it's really not called net to seller, but that's kind of the way we think about it. It's what must the seller sell for in order to net the amount that they want. So we will do a lot of those problems over the next couple of weeks. So you will, this is just kind of getting your feet warm, kind of see where you are and thinking about that logic. All right. So the next one said, if land costs $50 per front foot, how much is a piece of land worth that is 200 feet by 300 feet? So the 300 feet.
See your screen.
Yeah, the 300 feet. No, you shouldn't be. I'm just reading it. So for this one, the 300 feet, okay, is a distractor. It's a distractor. So it said that we had 200 front feet, right? But the lot was actually 200 by 300. So if we were drawing out the lot, okay, it's 200 by 300. But if this is the street, then this is my front feet. So the 300 was a distractor. So it was just in there to throw you off. So the actual math was 200 front feet times whatever the price was. Make sense?
Yes.
Yep.
50, okay. All right. So let's see. Number 8 says that you have a loan for $300,000. Your interest rate is 5%. How much interest will you pay for the first year? Okay. So that's a very simple, straightforward one. So you've got 300,000 times 5%. You're going to pay $15,000 for the first year. Okay. So now we would take that and we'd say, okay, divided by 365, and that gives you the amount of interest per day. Right. But in pre-licensing, we use a 360-day calendar, not a 365. So when we use a 360-day calendar, it makes it easy because that makes 30 days in every single month. So you don't have to know that January is 31 and February is 28 and March is 31 and April is 30. Every month is 30 days. So for pre, we do 360 and 30. Okay, we do 360 and 30. So that's kind of why I'll walk you into that one. Whoops. Any questions on that one? Okay. Number 9. Anybody had any trouble with that? That's what we did today, tax rate. Everybody good with that?
Yes.
Okay, and if you have to get 75% on the final exam, the exam has 120 questions, how many can you miss?
30.
You can miss 30, okay? So that one was just kind of thrown in there. So that should give you a pretty good gauge as to how you're feeling about your math skills, and where you think, you know, you might be strong or weak or whatever.
Jane?
Yes.
I know we did number 9 today, but what was the answer?
The answer was 2505. I mean, we did one like it. So 2505.
Okay. Thank
So
you.
150,000 divided by 100 gives you 1,500 times 1.67, 2505.
Gotcha. Okay.
Okay.
Thank you.
All righty. So does anybody have questions about anything before we call it a day today? Okay, so how's the breakup of things going? The break's okay? You getting enough break, enough lunch break to not go crazy staring at the screen? Give me a little bit of feedback. This is our first 8-hour a day Zoom pre-class. Okay, post is a little different.
I
Post is only
absolutely
4 days.
love the
They're not in a row.
15-minute breaks every hour. It's so helpful.
Breaks
Thank
are
you
good. Okay.
This is the first online course I've took. I'm really enjoying it.
Good. Good.
Me too. Me too. This is my first as well, and this has been the best so far, for sure.
Yeah.
Very
Right.
informative.
Me too.